Hey, yo, folks. All right. I just got back from work, so I set everything up, trying to get a bite to eat. And yeah, here we go. Streaming from
language
Intrinsic channel
the
because
proposed instruction.
she is now in the
I believe that
pool.
it was asked that the jury be apprised that Chief Judge Glanville was removed and that they are to disregard any comments made that were disparaging to defense attorneys. Your Honor, we believe that it would be better to say that Your Honor is now presiding over this trial. As it relates to disregarding comments made that were disparaging to defense attorneys, I don't think it's appropriate for this court to comment on subjective nature or what the intent was regarding comments made by Chief Judge Glanville.
Okay.
Seems like the prosecution is still whining about, please don't...
Anything else?
Please, Judge, our very familiar family-oriented stuff that we argued in the illegal ex parte, please ignore it, Your Honor. Please, please. Ass.
That's the
Okay,
only one.
thank you. All right. So obviously, I think the first thing I need to say is my name's Judge Whitaker, which I'll do, which really has nothing to do with this particular charge. But so I think the first sentence, Judge Glanville is no longer the judge presiding over this case for which you've been selected and sworn to try. That's fine. There's no objection to that. As I understand, there's an objection to Judge Glanville was removed as the presiding judge. I would propose as a compromise, maybe just I will be the presiding judge in this case moving forward. Then you're not to concern yourself with the change, which is already there. And I would just preface the next proposed sentence that is in a trial, none of the decisions of the court.
Okay. They are now arguing, what are they supposed to tell the jury when they come back? As in, what's the jury instruction for them? When they sit down, completely new judge. They might have, oh, why is that? And of course, the defense really wants to have the language, he was yeeted. The prosecution, somewhat lazier and not as inflammatory, and the judge somewhere in between.
Nothing the judge says is evidence. I mean, that's true, and that's a legitimate charge. I'll give that. I would just say, let me remind you, as I assume presiding duties in this case, that in a trial, none of the decisions the court makes, et cetera, et cetera. And then with regard to disregard any comments made by Judge Glanville that were disparaging of the defense lawyers, I would propose, because I am not supposed to be commenting on the evidence either, you are to disregard any comments made by Judge Glanville that may have been disparaging of any of the lawyers in this case.
Your Honor, would the court consider not instructing the jury as to anything?
If you want to think of some different language, I'll consider it, but that's what I'm thinking right now. I mean, he did make comments disparaging.
Good. Yeah. Tell the jury that Glanville blew his back out carrying the state on this case and had to be relieved. Now, what the judge
Thinking right now.
say here.
I mean, he did make comments disparaging of lawyers. That's not evidence. It's nothing. There's nothing wrong with me saying disregard that. So that's where I am right now. If you want to propose something else.
Hopefully, the jury will take notice that if those are said in direct holy crap. No, that's not in the instruction, but the Japanese Yakuza won for a Swedish 1,000 krona. Well, that is $100 super chat. Thank you so much, the Japanese Yakuza, saying, yeet, this whole trial. I hope so. It doesn't look like that's going to happen, but there is still it's a possibility, but I wouldn't bet money on it. Thank you so much. That is so nice of you. Thank you so much. And John Commune, $5. Thank you. The judge needs to ask the jury, what, if anything, have you heard since the last day you were in? There may be a mistrial right there. Yeah, but the defense doesn't want just a mistrial. They want it with prejudice. If the jury comes in, then it will be a mistrial. If a handful of them says something negative. So we'll just have to wait and see. But in my opinion, it's impossible for the juries to not have heard anything.
And propose it.
Orally or in writing? Does the court mind orally?
Sure, go ahead.
There.
You are to disregard any commentary, any comments that you deem commentary on counsel for either side.
So instead of disparaging,
Yes, that's assuming that there were disparaging.
well, that's why I'm saying that may have been. So that may have been comment.
Characteristic says, until a judge rules Gravel did something improper, I don't think it's fair to comment on his removal in anything but a neutral way. He did do something improper, but that is... I understand what you mean. He did do something improper to get him yeeted, but what he did not was not in front of the jury. It has to be in front of the jury, more or less.
Terry? Well, I mean, right. He shouldn't, it's irrelevant whether he said, you are doing a fantastic job today either. So, all right, maybe craft it a little bit more. And I understand what you're saying. So if you want to come up with a word that kind of encapsulates disparaging or complimentary, let me know. Anything from the defense, or y'all just want to wait and see what she comes up with and then talk about that?
I don't have an objection to the part that you said about what you said.
All right.
I do not see the need to add also complimentary.
No, I don't think we should either. I wasn't suggesting that. I'm saying if we don't say disparaging, then let's come up with a word that would encapsulate any kind of commentary whatsoever, whether it's flattering or non-flattering.
But it should be disparaging. That's my point.
It might stay like that, but.
And I think that I heard what you said, but I would continue to ask if you think it's appropriate to reconsider about Judge Granville has been removed.
Okay.
Other than that, I don't have any other objection.
All right. Okay, so we'll leave that for now. And if you, Ms. Love, want to propose another word or phrase, let me know. Otherwise, it'll read as I read it.
Yes, Your Honor.
All right, thank you. Okay.
Excuse me.
Yes.
May I bring up a brief issue before
Absolutely.
you continue? You mentioned this morning about that the court had several rulings that you put out yesterday.
Yeah.
I have not received any of those rulings on Odyssey. I haven't received any of the submissions from Mr. Steele that came through Odyssey. I know I've talked to several other counsel, but I haven't polled everybody.
Okay.
So I don't know what the issue is, but I'm not receiving
The issue is Odyssey.
Okay, yeah. So given I can investigate that today.
And I can't do anything about that. I mean, Odyssey. So.
Anybody can email the rulings out?
Sure, and usually at least the lawyers seem to get things fairly contemporaneously. I know the court doesn't always get things contemporaneously, but, and it sounds like some of the lawyers have received rulings. I know Mr. Steele received some because he filed a petition for a certificate of immediate review about 5 minutes after I filed one of the rulings as to one of his motions. So I don't know what the vagaries of Odyssey are and why sometimes it seems instant and sometimes it doesn't. But yeah, I don't have a problem with, as I file orders, emailing them out to everybody, just like I asked that y'all email me with your motions and responses. So sure, we can do that going forward.
Thank you, Doug.
Okay.
I believe what's going on, Your Honor, and just my observation, is that the use of the co-defendant, this is insurance contact.
You're exactly right.
In this case, for some reason, it's like they have this separate cases.
Yeah.
For everyone.
Okay. So yeah, and I do not think that we have been filing our orders in everybody's case individually, every co-defendant's case individually. I think we've been filing them, like, for instance, if Mr. Kendrick files a motion and I'm ruling on that motion, I understand y'all have all adopted it unless, you say differently. But I think we've been filing it into Mr. Kendrick's case. And so that is exactly right, Mr. Short. That's what's been going on.
Yeah, for some reason, previously, we were receiving.
Okay.
So I don't know what's altered, but.
Well, maybe what's altered is that somebody on Judge Glanville's staff was individually filing it in every case, and I haven't been, and the clerk's office, I guess, hasn't known to spread it out into the other cases. So that's what's going on instead.
Thank you.
Okay. All right. Thanks for bringing that to my attention. All right, so are we ready with any portion of Mr. Kendrick's testimony? What did I say? Copeland, yes. Kendrick, I said Kendrick. Yes. Are we ready with any portion of going?
Okay, we are going right into how, well, they already know they have to go back a bit on Woody's testimony to the 12th, but he testified after the 12th as well. And if the question the judge said to the parties is there anything in his testimony after the 12th you can stipulate in keeping in? So I guess that is part of what we're going to do now.
Back either any kind of agreement as to what's already been testified to, and if y'all haven't been able to do that yet, then, hashing through the evidence that we're going to have to face again.
So, Your Honor, there's several statements. I think what's really helpful is when we have, and we do have some of the transcripts now where we argued, so that can kind of prompt everyone's memory. And last time we had to go through all the contested segments. What we did is the state played them in court, and then we made our individual arguments. And now that we have the transcripts of regarding some of the statements, I think we're ready to do that.
Great.
And it's just, I'm just giving the court a heads up. It's going to be somewhat maybe disjointed at times, but we just got to plow through it. And myself and Ms. Hilton did the best we could to try to figure out where we were previously. I don't believe for the uncontested issues, I don't believe the uncontested issues have changed at all. I believe I speak for everyone on the defense that we haven't changed our view on the things that we agreed with the state. I think we just need to go over the contested issues.
Okay, that works.
Do you have the ability to play the statements, the court today?
Yes.
Okay, good.
And
and the other thing I was going to say, the January 11th is the first, January 10th going into the 11th is the first statement by Copeland, and logically maybe that would be the first one we review, but I don't believe that myself or Ms. Hilton saw a transcript of our prior argument of that one.
Okay.
So I would ask if we could start with the other ones first.
Yeah, that's fine. Yeah, I think there's still one day maybe that Ms. Weaver's working on. So that may be the day you're talking about. So yeah, we can start on whatever the next statement was.
I changed
And
the
are you
frame a
going to
bit,
be
so I-
playing
well,
these through Zoom? So
Once
do I need
Miss
to go on
Love
Zoom?
sits down, I
Yes,
cover
Your
her
Honor.
head.
You do need to get on Zoom.
And do you have transcripts of the statements that are going to be at issue?
Yes, we do have transcripts. What I wanted to know from the defense, if there were any that were litigated that are agreed upon, because if there are some that were litigated that we don't have issue with moving forward, I don't know if we need to rehash everything, and we haven't had that conversation, so I don't know.
All right, do you want to take a minute and have that conversation?
Yes.
I think I can answer that. I think anything that was litigated before needs to be litigated again.
Okay.
And regarding the transcripts, Your Honor,
June 10th, we have the same imperfect transcript, but it's generally gives good guidance. For some of the other interviews, the state has a transcript. There wasn't like an official
All right, now,
transcript.
when you say June 10th, are you talking about his June 10th statement or our transcript
I'm sorry.
from June 10th of this year?
June
You mean
10th.
his June 10th statement? Okay.
2015. The state produced a transcript of that, and it's not perfect, but it gives
Okay.
guidance, and we're working off the same transcript.
Great.
For some of the other interviews, the state made a transcript at some point. Maybe, I don't know who made it, but it wasn't disseminated to us, and we made our own transcript,
Okay.
so we have like dueling transcripts. Just
Okay, well, that's not for June 10th though, right?
No.
Okay, so maybe before we get to whichever statement has the dueling transcripts, y'all look at each other's transcript and decide which one you want to go by, or if some parts of it are better transcribed on one and some parts on another, combine them and let's get the most accurate transcript.
and that's why we were playing the statements in court.
Sure.
I just want to give.
Yeah, but
Because Judge Granville asked for a transcript and there was a complete agreement on the transcript.
Yeah. And there, it's certainly a lot easier and frankly a lot faster with a transcript. So if there is a statement that I particularly need to see and hear the statement for the evidentiary determination I'm going to make, that's one thing. But if it takes me 5 minutes to read a transcript or 20 minutes to watch the statement, I'm going with the 5 minutes unless there's a reason I need to be watching the video instead. Okay. Because I mean, honestly, for most of these evidentiary issues, I'm not here like making a credibility determination.
I have to. I got a donation via PayPal, and for $100 from. It's not the same name in the chat that is on there, but the Japanese Yakuza. Thank you so much. Thank you. You are. Thank you. Thank you. Thank you. Thank you. That is extremely generous of you. Extremely generous. Thank you so much.
Determination. For the most part, that's for the jury. I'm here trying to decide, does this evidence come in under XYZ exception under the law? Okay. However, right now I don't have any transcripts. So pass up whichever statement we're going to be looking at right now. If it's June 10th, 2015.
Can I email it to you? Like I don't have a.
Yeah, that's fine. In fact, we might have some transcripts of certain of the statements. So
In natural breaks in this, there's a few motions and replies and stuff we can go through. I didn't start early because I need something for you in the breaks and the comfort breaks and stuff like that.
Ms. Weaver provided our chambers with several of the transcripts of the statements that y'all had given to them, I guess. So I've got the transcript of that June 10th. And I actually have videos of some of his interviews too. I think maybe all of them, but some of them play under evidence viewer that y'all gave to me and some of them don't.
So, if you received 6 interviews, if you received 6, 5 of the 6 are all evidence reviewer.
Okay.
And then the only one that's not evidence reviewer is the October 2021 interview.
All right. Okay. So
Yar!
I need to get on Zoom.
Yar is
Give me
here.
a second to do that.
And can I have the link as well, Your Honor?
Okay.
Oh, and another thing. Today I officially started my vacation. So happy Friday for you all. And on Wednesday I will be flying into the United States. So not a lot of days until I will be in Houston and starting my road trip across the United States.
Your Honor, may I, please use for a brief moment?
Sure.
And on the 14th, I will be in Atlanta, 14 to 15 of August, and I will be in that very courtroom. No curious sense. Yeah. No trial today. This is evidentiary stuff, and especially at the time, right now, it's about Woody's testimony, what they can keep in and what they have to rehash. So, in my personal opinion, since the ex parte hearing that set everything off was on the 10th, and they had another ex parte meeting, another secret ex parte meeting on the 7th. For me, the natural thing to do is not to go where...
June 10th, 2015.
Is to not go back to when the defense filed their motion to recuse. It should be all the way back. Sadly, the Judge Krause doesn't agree, because she said only the recusal motion and how Glanville reacted to that one. That is the only thing that counts. And thank you to Reform Convict. $2. Thank you so much. Living on gov teeth sucks. Get some peanuts traveling. Thank you. But if you are on unlimited funds, you don't have to do that. Please don't. I mean, I'm doing fine, and I mean, people have been donating through PayPal, and I'm good. Especially if you have an in access and really want to pour your money on me, I will not disagree with it. But if you are on a fixed income, please keep it. But thank you so much, Reform Convict. Thank you.
Statement of Mr. Copeland to law enforcement, and we're all working off of the same transcript, and you're going to play the video as necessary.
Yes, Your Honor.
All right. Ready when you are. With regard to whatever portions of this are contested, tell me where they are, I guess, timestamp in the video, as well as what portion of the transcript, and then tell me what the dispute is, okay?
Your Honor, since my mic is not, doesn't seem to be working.
Yeah, you can just come up here. Sure. Lon, can you shoot?
Hey, Brandon is here. Hello, Brandon.
And if not, then we'll just get it live.
To the, yeah. They have proposed,
All right, tell me.
yes, Your Honor, just to orient the court.
Sure.
So the state had proposed several redactions of portions of the interview that we did not want played.
Mhm.
And the defense, for certain portions, wanted that portion to be played through the state.
Okay.
It's the state's position that if we don't play it, and they choose to play, they can, unless we believe it's inadmissible.
Okay, so with regard to any of those portions that you just think, they don't need to hear this, but the defense wants to play, I guess, have y'all talked about whether the defense intends to play it so that you can tell me whether you think it's inadmissible?
Yes, it's
Okay.
so I just want to
All
order
right.
the jury that that's.
All right.
Where we are. So with respect to the June 10th interview, the first section, I'll just go in chronological order, that there was an objection. The defense wanted to redact timestamp 10:19 to 10:11. I mean, I guess I'll let defense counsel explain why they wanted
10:19 to 10:11.
10:19:11 to 10:19:41, which is page 61, line 22 of beginning at page 61, line 22 through page 62, line 14.
Okay, so they are back now to where they were during Mr. Copeland's, Woody's statement. What evidence is allowed in? This will be fun. Skipping ahead.
This is a segment that defense counsel, you want it redacted, but we objected to it being redacted.
Okay, so this is what you, because a minute ago you said stuff you're not gonna play, but the defense wants. So now you want this, the defense doesn't.
Correct, Your Honor. So the way that we had organized it initially,
I mean, if we're just gonna walk through the whole transcript and then, that's fine. That's fine. I just need to understand what it is.
yes, so this was a portion that the
You
defense-
want, the defense doesn't.
Yes.
Okay, and that is, I know it's 1019-41, no, 1019-11 to 1019-41.
Yes, Your Honor.
Okay, all right.
There's going to be a lot of skipping forward today.
To get it right.
Oh.
Right now, we're starting at 10:18:52 with evidence reviewers. Sometimes a challenge to get it right at the.
Hey,
Right
Linfield,
timestamps.
any good arguments so far? No.
All right, let me ask. So I had just said, I don't know that we need to actually listen to the video of everything. And I mean, I can read the words on the screen, so on the transcript. So unless we also, for some reason, I need to be hearing it out of his mouth. And if I do, and there may be times I do, then we'll listen on the video. But if I don't, I can read it.
So the safe position is, we want to hear from the defense, but I think it's inadmissible. So that's what we were waiting for.
Okay.
Okay, so just a little context, if we're just looking at the statement as,
My legal assistant failed to turn on my mic. If we're just looking at this, the transcript, add some context.
Well, no, let me stop you. If you, for a reason, want me to watch the video, that's fine. I don't have a problem with it. I'm just trying to be efficient with our time.
No,
You mean, let me tell you what's been going on beforehand. All right, sure.
So they were discussing beforehand the Lil Wayne bus shooting.
Okay.
In this discussion. And then Kenneth Copeland on line 9 of page 61 says they did it. Who is they? And they who? And he says, Shannon and them. So the first part of our objection is Kenneth Copeland giving information about the Lil Wayne bus shooting. What Your Honor needs to know from me about the Lil Wayne bus shooting is Kenneth Copeland, it's not been alleged at all that he was at Club Compound on the night of the Lil Wayne bus shooting. It's not been alleged at all that he was present, that he was there, that he had anything to do with it. So, and it is not at all clear. So it's clearly hearsay. I need to search for an exception. And I don't know what the source of his information is. There were, this was Dwayne Carter is Lil Wayne, and when his bus was shot, there was all sorts of internet reports on gossip blogs and everything else. And there's just no way to ferret out what his source is.
Sure.
To suggest that it falls under any hearsay exception.
Okay.
Now, I have in my notes on the transcript that page 61, lines 1 through 10, were not objectionable. That's what my notes said.
Okay, that's right.
And then
Hang on. Let's make sure that's right. That's right.
What line did you say?
62, lines 1 through 10.
So, Your Honor.
62 or 61?
Oh, well, 61 as well, both. It starts on line 11 or somewhere about there.
So you want to ensure that y'all are in agreement that 61 lines 1 through 10 are in unobjectionable?
And Your Honor, we need 2 rulings before we can answer that.
Okay.
So initially, that was the case. However, Your Honor, based upon, we filed the notice of intrinsic acts that we would need to hear if this intrinsic act regarding the Lil Wayne bus shooting, specifically as it relates to Shannon Stillwell, if that is able to come in, then we would want to play the portions, page 61, starting at line 1. Also, Your Honor, depending on the court's ruling on co-conspirator hearsay, co-conspirator statements, excuse me, we would,
Well, I can't just give you a blanket rule on co-conspirator statements. I have to know what the statement is.
yes, Your Honor, so that would be my response to this question. What Mr. Shard just argued is that what,
He's not arguing anything right now. He's trying to make sure we're all on the same page. So
Well, we are back to those people are back on what does the prosecution want played to the jury, and the defense objects because of reasons. We spent, I don't know how many days already on this, back from when Woody testified, but in my personal opinion, none of it. Why? Because Hilton read from that more or less the entire police report and transcript during the interview with Woody. So it's compound or in excess, yada yada. But I'm not the one who is making the rulings here. If I did, the trial wouldn't have surpassed day 25.
correct. And so what I'm getting ready to say is what Mr. Copeland is speaking with the detectives about, which is the Little Wayne bus shooting.
right.
This is information that the state believes he received from Demekion Garlington, a co-conspirator.
Okay.
And so we believe that this would fall under a co-conspirator statement as an
Again, Woody claims that Garland said that they did it. That is third-hand information. But there are so many exceptions to the hearsay rule, it's ridiculous.
furtherance of the gang. So because he's telling him about an act that occurred between these gang members, and to give the court a little more context, the Little Wayne bus shooting, what we call it, is one of the acts. We've already presented evidence about this act. It occurred in April of 2015 in the midst of what we believe to be an all-out gang war with YSL. Essentially, the state's allegations are that Mr. Williams was in conflict with Dwayne Carter, also known as Little Wayne.
Thank you, Brandon, for your $5 super chat. Who says, just wanted to put it on the record. I predicted you would be covering this for over a year before it started. You did. That it was back in June or July of last year, when you actually said, when I started to talk about, I'm going to cover this and this and that, Brandon says, this will take over a year. And I actually argued against Brandon. No, Judge Glanville clearly says this will be a 6-month trial. I was wrong back then, a year ago. I was so wrong. And here we are. I've been covering this case since end of May of last year. 14 months going on 15 months now. Holy crap.
In the evening in Atlanta, several members of YSL went to a venue in which Mr. Carter was performing, and they created some type of ruckus outside of the venue. Later on that evening, a number of YSL members followed Mr. Carter's tour bus to essentially to their hotel or en route to their hotel and shot at their tour bus. What Mr. Copeland tells police is that Demekion Garlington told him that the individuals that shot at the bus were DK, who's also known as Walter Murphy, a YSL member, and Shannon Stillwell, a YSL member. Jimmy Winfrey, another YSL member, actually ended up pleading to the case.
Okay.
And so we believe that this will be a co-conspirator statement. So that is kind of the context of that statement here, Your Honor.
All right. So what Mr. Sharp was trying to.
Gwenin Garnett asks, is there any evidence other than gossip for any of the underlying acts? In my opinion, on few occasions, the prosecution has presented what they call evidence, as in the surveillance camera of the drive-by, photographs of crime scenes. But I mean, it's gossip. What was it? Doug Weinstein said that prosecution, they are gossiping like yentas.
You sort out is, do you have, sounds like you had previously, and by you now I mean the state, had no objection to lines 1 through 10 of page 61 coming in. Is that still your position?
No objection of it coming in. Yes, we have no objection of it being played.
Okay,
Right, that was never an issue.
okay, and it's still not. All right.
So, and I don't think we need a ruling on the intrinsic. I mean, this doesn't really further my interest, but just to be honest with the court, I don't think this is an issue of whether it's an intrinsic act, because it's pled in an indictment as an overt act.
Yeah.
Part 1. So
Okay.
I don't think that's the issue. The issue is the state is just saying, well, we think he got this information from Demekion Garlington. There's 2 issues. A, we think he got this information from Demekion Garlington. I don't know where they're getting that from. That's 1, other than speculation. 2, then it also, if they were to be able to show that he was the source and that he's a conspirator, then we would also have to, it sounds a lot like spilling beans. So there's 2 aspects of that where the state, the burden is on the state, and I just don't see them meeting it.
So, DK, I'm sorry, y'all, it's gonna take me a minute to get all the names. DK is who in real life?
Walter.
And Mr. Garlington goes by D, right? Who is little D?
There's 2 little Ds.
There are 2 of like lots of these people. Okay.
So one will be referenced as little D from Mechanicsville, and that'll be
Obvious,
Demekion
reasonable
Garlington.
doubt.
Okay. So does he go by like both D and Lil D?
Primarily little D.
Okay. And he's Garlington, but he'll be Lil D from Mechanicsville.
Yeah, he also is referred to as Scarface
Okay.
in the indictment.
All right. And then the other little D will be,
Quindarius Zachary, Quindarius.
and when they say Lil D,
From Cleveland.
Cleveland. All right. So we got
And they also call him Sick D.
Sick D, Lil D, or Sick D. And he'll be from Cleveland. Okay, thank you.
And Your Honor, it's not speculation that Demekion told him this information. On page 61, line 22 through 24, Mr. Copeland says, little D, that's how I get all my information, through little D.
That is still hearsay. That is speculating that Woody is truthful.
Which little D? D ain't, and they clarify, he says Mechanicsville, which is Demekion Garlington.
Okay.
I'm just not reading it that way.
All right, let's see. So maybe we'll listen to it. See, this might be one of those times when we need to listen to it.
Oh, good Lord.
And Your Honor,
I need to fetch me some more
sorry, about
nicotine
10:18:52.
pouches.
Okay.
But we're going to be
Right
listening
back.
around 10:19:12.
All right.
They like shit. It was on Shannon DK them. DK right here for you? July, yeah. What about Liddy? That's how I get all my information to Liddy. The yeah. See, he's not gonna be able to tweet all day, Twitter and Instagram. This is all he gonna do all day. I mean, he gonna be everybody, get a bitch, everybody. I mean, talk to them. You know what I mean? So I would say, hey, like that, I can't be right now. Every other he'll say right there what's going on. So, well, I don't know what it is about this, bro. If you know you ain't gonna plan on killing me, bro, why you never told me? You know what I'm saying? Say you plan on killing Tick too. Shannon gonna kill Tick. Nah, look. Why the other kill Tick, bro?
And I can replay it, Your Honor, if you need me to.
So, Your Honor, this is my problem with this argument here. Typically, in every case I've ever dealt with a co-conspirator statement, every case I've ever read involving a co-conspirator statement, appeal, the declarant said to witness approximately 2 weeks after the murder, while at the Exxon gas station, that it was the defendant and his friend that committed the murder, and that the person needs to be quiet about it, etc. There's a time, there's a place, there's what was said, it's who said it. Here, Mr. Copeland comes out with some hearsay, some vague hearsay information about the Lil Wayne shooting and who did it. They ask him, what about Lil D? And it seems, I'll concede it seems we're talking about Garlington. And Investigator Dennis is the one talking, and he's clearly asking about Mikion Garlington, I think. I think that's fair. And he just says, well, Lil D, that's where I get all my information. He's on Twitter a lot. He gossips a lot, essentially is what he's saying. There's, I don't take a general statement of, oh, Lil D, he's a gossiper, that's where I get all my information, as sufficiently specific to this particular piece of information to say, Mikion Garlington told me, and I know you don't need an exact date, but Mikion Garlington told me, about a week after the Lil Wayne, if the state wanted to bring this in, I would expect to hear, yes, Mikion Garland told me about a week after the shooting, we were hanging out at the Exxon gas station, and he told me Shannon and DK did this, but that's not what we have here. It's just a vague statement. Oh yeah, I get all my information from Lil D. So I don't think that's sufficient to particularly say that he's the source of that particular information. And then of course, again, it's spilling the beans when it really comes down to it too, because there's no context that would lead anyone would allow Your Honor or any of us to conclude that the state has proved by preponderance of evidence that somehow a statement that we don't even know was made, where it was made, the context of what it was made, was somehow in furtherance of any sort of conspiracy. So I just don't see how you are armed with making any sort of determination that it falls under 801 D2E. And of course, the burden is on the state to arm you with that information.
I agree with Mr. Short. This interview is a week later, and Woody is extremely vague. So I'm just glad nobody's called Little
While you're
D.
reviewing this, with all due respect, I want to renew my motion for mistrial based upon the entirety of the record up to this point. I think it's impossible for you to jump parachute into this. I think this morning demonstrates why it's very difficult for the court to do that without having the background of the last 6 months of testimony. We're now replowing people issues.
All right, we're replowing because everybody agrees that, and I don't mean to interrupt you, but I want to clarify that. Everybody agrees that everything that Mr. Copeland testified to in front of the jury after the motion to recuse was filed on June 12th has to be redone. So that's why we're replowing this.
No,
go ahead.
Okay, but
yes, I don't know everybody's nickname yet. That's true. But this is not in front of the jury, and evidentially, I'll either make the right ruling or I'll make the legally incorrect ruling. And that's something for potential appeal. That's true in every case. And I don't ever know the facts of a case before I start to take, it to trial. I find out in the course of the trial, or I find out as the motion is being presented. So yes, it would certainly be easier if I had heard 6 months of testimony that came before this, but I don't think it is a basis for mistrial.
I disagree entirely. You would know the basis and the people's names in the testimony had you been the trial judge up to this point. And I get your point. Before trial, you don't necessarily know the evidence. We are way deep into trial now. You would have heard this evidence. You would understand the context, and we wouldn't have to replow the contextual basis. So I'm just renewing my motion.
All right, I appreciate it. You're not wrong about factually speaking, it is more difficult, but legally speaking, it is overruled.
Your Honor, can I
Mr. Steele.
Could you mind, as you're making this analysis under OCGA section 24-8-801 D2E, I'd like the court to just denote that in a good case is, but I think it's a good case, is Stafford, Stafford versus State. That is 312 Georgia, 811. It's in Division 5A as in Elisa, 865 Southeast 2D 116, 2021 case. And the reason, I'm listening intently, I don't mean to interrupt, but the state's belief of the law over the past year is that any statement made by a supposed co-conspirator to another co-conspirator who speaks with the police furthers a conspiracy. And as Mr. Shart said, that is just spilling the beans unless it really does something to promote the conspiracy. So even what the state just said, I get my information from Mr. Garlington. My point is that doesn't help the state, because if I'm in a conspiracy with Mr. Adams to steal a pencil, and I tell Mr. Adams, I stole the pencil, or Haley, who I'd like to introduce you to, stole the pencil as part of our conspiracy, Mr. Adams, then repeating that to law enforcement, doesn't do anything to assist us. Now, if he said cover for Haley, give her an alibi, that is different. So the point I'm trying to make to you is, I'm not so sure that there is a conspiracy. Like, I'm just telling you, I know you're working hard, and it's all appreciated, but Mr. Nichols hasn't really been mentioned in this case. He was not mentioned in opening statement. He has one little section on I can't remember the year, 2014, but I don't know the year, small drug case. Otherwise, he's not mentioned. And that, I'm not trying to argue for the Honorable Ms. Westmore and Mr. Harvey, but that's why he's always asking for 105 instruction. But the point I'm trying to make to you is, this exercise also has to inject, if you don't mind, why the state is saying it furthers a conspiracy. Just getting information does not further a conspiracy. That's my point. Thank you.
Thank you.
Okay, Your Honor, if I can add some additional facts, because I don't want to. This is not the only time in this interview that Mr. Copeland talks about the Lil Wayne bus shooting. So
Here's the then that should be rehashed too, because if the first part isn't admissible, then the second part or the third part or the fourth part, because if they are all connected in a chain link, but it's broken in the beginning, there's no link. That is, I mean, you can get to, let's see what happened in hour 11 of this police interview in order to get into evidence what happened in hour 1. You have to, this is not good.
this is
in my
the
opinion.
first time he actually talks about.
What is this happening? Look here, I have a minute and a half buffered up, and it still does the whirl of, I have had my computer on for maybe 36 hours because I've been remotely trying to get documents and stuff. If you wouldn't mind, folks, give me 90 seconds to restart everything here, okay? Maybe that will help somewhat. Let's see. I will be right back. And I'm back. All right. Dun, dun, dun. Let's try to get this up and running again. And there, and there, and there. And here we go again.
Hang on. Here it is. Hearsay statement file about co-conspirator state.
9 hours long.
Mm-hmm.
And so
Okay, I have to go back a bit more.
this is not the only time in this interview that Mr. Copeland talks about the Little Wayne
No,
bus shooting.
we're-
So this is the first time he actually talks about the details of the shooting. At least 2 more times throughout the course of this interview. So this interview is 9 hours long.
Mm-hmm.
And so in the course of that interview, he gives more and more details about the shooting.
All right,
That
maybe
he's-
point me to the parts of that. So I don't know if you were able to pull up Stafford or if you have it, if you've looked at it previously, but what it says is the same thing that Mr. Sharp's been arguing for a while about co-conspirator statements. And that is essentially that even where there is a conspiracy that has been established by a preponderance, no, I lost my place. Hang on.
As Heather Marshall says. No, sorry.
Here it
Copeland
is.
wasn't even
Hearsay
there.
statements that implicate a co-conspirator but do not advance any object of the conspiracy, such as statements that merely spill the beans about the conspiracy, are not admissible. So if you can
Yes.
point me to how
The state
this
has to argue.
advanced the conspiracy, and I understand.
The state has to argue why this is not the spill the beans, because that's not admissible. It has to be in furtherance. That is the standard. And to my knowledge and opinion, they never had to argue that before Judge Glanville.
And your argument is, hey, the conspiracy is they're all members of an ongoing gang. They need to know what's going on in the gang so they can react like appropriate gang members and be prepared if somebody's coming after them. And that's a reasonable position to take. So tell me how it is that this is advancing an object of the conspiracy and not theoretically where your evidence is going to show that.
Yes, Your Honor. So during 2015, there were just a number of different events and actions that took place beginning in January of 2015, all the way through about October of 2015, Your Honor. This particular shooting of Lil Wayne's tour bus was a part of 2 events. So Lil Wayne, I'm trying to simplify how Mr. Carter is a part of this. So starting in 2014, Your Honor, Mr. Williams had began a musical relationship with a person by the name of Brian Williams, also known as Birdman. Lil
It is
Wayne
all over the place.
was one of Birdman's artists at the time, back in 2014 and prior to that.
She asked for
Evidence has
actual
come
evidence.
in that members of YSL, specifically, have made threats against individuals who we believe supported Lil Wayne during this ongoing dispute that they were having.
Is Birdman alleged to be?
Sorry for interrupting. But you haven't presented those evidence yet. You need to have those evidence in before you reference the... Huh?
in a rival gang, or he's just a rival record producer in the industry?
He wasn't a rival to Mr. Williams, so he was friendly with Mr. Williams. Lil Wayne, we believe, became a rival, and we're talking about back in 2014 and 2015, of Mr. Williams at some point. At some point, there was some friction between the two of them in which Mr. Williams made subtle threats to Lil Wayne via social media. That evidence has been entered before this jury. And we believe that the gang, when Mr. Carter came to Atlanta, there again, like I said earlier, members of YSL like just converged on the compound. They left their different, I think they were at a music studio. They all came there in an effort to intimidate or threaten Mr. Carter.
Okay.
So informing another gang member of those activities is keeping him abreast of those activities. I believe that Mr. Copeland, we're going to confirm, was incarcerated at the time of the Lil Wayne bus shooting. And I want to make sure I confirm that for the record. So we believe that he was being kept abreast of what was happening while he was incarcerated. And then once he was released, he was provided this information in order to, whatever the next steps were, whether it would be to further intimidate Mr. Carter, but he was made aware of everything that occurred while he was in custody.
So do you have any evidence that then when he got out of custody, he also began to participate in this threatening of Lil Wayne and his peeps?
No, we do not have any evidence.
Okay, so then how is it furthering the conspiracy of being in the YSL gang and not just, hey, guess what happened today?
Because it fosters cohesiveness, the fact that this YSL gang could literally shoot at a bus of a famous individual.
According, Lil Pill asked, was there actually evidence of them making threats to Lil Wayne on social media? In my opinion, no. There was banter between Lil Wayne and Young Thug at one point. But that was more or less equivalent to a rap battle, maybe. But according to the state, those are serious threats. That's the evidence.
It made the news. It promoted the notoriety of YSL.
Yeah, the shooting might have, but how is telling Mr. Copeland doing anything to further it?
Because he then can claim notoriety as being a member of YSL.
That helps him? How does that help the gang?
Because it promotes their notoriety, the fact that YSL themselves had the ability to shoot at a famous person. That promotes the gang across. It made headline news. It made news.
That may be. Again, how does then apprising Mr. Copeland of it further the purposes of the gang?
Because it furthers his involvement, because he's still in the gang. He can still promote himself. He still promoted himself as YSL, as being a part of the group that shot at the Lil Wayne's tour bus.
Do you have any evidence that he does that?
Promotes himself as YSL?
As, hey, I'm part of the group that shot up the bus.
I don't have evidence of him saying I have evidence of him saying he's still part of YSL and claiming affiliation with YSL, because collectively they shot up the bus, not the specific individuals, but collectively as a group, they shot at.
Does he post or brag about YSL shooting up the bus?
Nope.
No, we do not have any evidence of him
right.
posting on social media YSL shooting up the bus.
Okay.
Do you have? I don't think they have anyone bragging or anything. They have vaguely lyric something, but they actually don't have any evidence presented so far that anybody in the alleged YSL criminal street gang bragged about shooting up Lil Wayne's bus. Good call, Judge, so far.
All right, so we are then looking at '61, line 22 through 62, line 14, where he says, I get all my information from Lil D. Because everybody's talking about it. He knows what's going on. And I don't think y'all have sufficiently satisfied the co-conspirator exception there. I'll keep that part out. Let's move on to the next one.
So, Your Honor.
Hello. What? Oh. Yep. Okay. That part is out. Now, here's the thing, folks. How will they show the other things if that part of the chain link is gone? They can't. That was essential, more or less essential for the prosecution to get other statements in as well. This will be interesting.
Then there's, and this is where I'm not sure what the state's, 62, the beginning of, I'm sorry, the beginning of 62, they just talk about from Mechanicsville just being a gossip. Now,
Yeah, that's what I just excluded.
well, you excluded, in my understanding, you excluded the part where he talks about the Lil Wayne bus shooting. And then after that information he gave, there's a section, and I don't have a strong
No,
opinion.
y'all all said nobody cared if that came in, 1 through 10, nobody cared.
Yeah, 62, 1 through 10, I agree. I don't have a strong opinion. I was just trying to understand what, if the state had an opinion about that, if all of that was coming out or all of it was coming in, the 1 through 10 on page 62. I don't have it.
No objection to it?
Yeah, no, 62, 1 to 10, the state is okay with coming.
Okay.
Okay.
I'm just trying to clarify. So
All right.
we're on the page. But then starting at 11 on page 62, there's another aspect of this where it's not the same issue. It's something about Kenneth Copeland talking about potentially Jeffrey was going to
Yeah.
have Tick, and Tick is a gentleman named Trontavious Stevens, who is also known as Slug, who is he entered a plea in this case.
Your Honor, that portion is redacted.
Okay,
62, line 15 through 22 will be redacted.
Okay.
All right. Next.
Speeding this. Oh, I'm already at
I
1.25.
believe the defense wanted, next page 62, line 23 through page 70, line 16.
This might lead to the judge denying a lot of statements if the state really
Turn
can't,
again, 62,
Page
line
63,
23.
yes,
via actual evidence, that it was in furtherance of this criminal enterprise. Eh,
line 23 through page 70, line 16.
16, okay.
Studuso Ndokwene. I'm so sorry for butchering this. We here. Says, I have to support Nick. He has invested too much time to this. Thank you. It's not too much. It's a lot of time. But thank you so much. Thank you. Skipping ahead. There's silence at the moment. Skipping ahead 5 seconds at the time.
All right.
Did I get it right?
My recollection
Hey!
is, and I'm not saying that the state's misrepresenting anything, but I don't recall having a blanket objection. Now, there's certain parts in this transcript as a whole, and they're coming up not to 72, but a little bit after 72 that go back to Lil Wayne bus shooting. And our stance is all that is covered under your last ruling. I mean, all of it's the same general situation. But regarding these pages, 61 to 72, what I have is I objected to 70, page 70, lines 16 to 19, where it's just Investigator Dennis identifying, it's not Copeland talking, but
Mhm.
Investigator Dennis says,
If Shannon is a shooter.
Shannon is meaning Jeffrey's shooter. Why would he put, and he's,
Yeah.
I think that's appropriate to have the investigator, just put that out there. And then after that,
Hi, Dave.
and then,
For you who don't know, I'm streaming infamous Sylvia's pooled coverage of this, since the judge 2 days ago said, well, Miss Sylvia's recording of this is poll number 2. Now you all need to subscribe to Infamous Sylvia so she gets enough subscribers and everything so she can provide live subtitles. Because she can't at the
Line
moment.
72, lines 5 through 13. Again, it's Investigator Dennis, kind of giving his theory on everything in relationship between Kenneth, Jeffrey, and Shannon. And it's not needed to add context to anything. It's just kind of him giving his theory.
All right.
So,
So does anybody have an objection to pages 62, line 23 through, I thought you said 70, line 16?
That's what
Anybody have an objection to that?
okay, I'm sorry. No.
Nobody has an objection. Speak now or forever hold your peace. All right, there's no objection to that.
And as it relates to what Mr. Shar just mentioned, page 70, lines
Six-
17 through 19, we have no objection to.
To
that.
redacting that?
No.
Okay, so 17 through 19 will be redacted. Page 70, lines 17 through 19.
And also, I believe what he just said, page 72,
Lines 5 through 13.
no objection to that.
All right,
Oh, I'm sorry, 72.
okay, next.
The next portion that I had initially was page 70, the defense wanted redacted was page 72, line 14 through page 73, line 21.
All right, does the defense still have an objection to that?
The 73 line.
No, 72, 14 through 21.
No, 72, line 14 through 73, line 21.
Okay,
Um,
God bless you.
no, I'm.
God bless you.
Speaking for Mr.
Okay.
Stillwell.
anybody, any of the defendants have an objection to that portion? Sounds like a no.
Then you're on the next portion, I believe would follow under your previous ruling, which would be redacted, which would be page 73, line 22 through page 78, line 16. So
Okay,
I don't think there needs to be any further discussion.
All look at us making progress.
Your Honor?
Yes.
Can I briefly have Red Stafford just address something briefly related to the case item? Your Honor, in regards to Stafford, it's quite distinguishable by the mere fact that it appears from reading this that this was a co-defendant's statement to the police and that co-defendant did not testify. So what they were arguing was a co-conspirator in furtherance of the conspiracy was what this individual told the police. We have Kenneth Copeland here on stand who can cross-examine, so it's not what he said verbatim to Detective Dennis, it's obviously what he stated other co-defendants.
Right.
And so I just think Stafford is quite distinguishable from the facts at hand, because there could be a situation where a co-conspirator is trying to throw off the police, tells them a lot of lies, which furthers the conspiracy, but that's not the situation we have with Mr. Copeland, who's live, and cross-examined.
Okay. I appreciate that. And when I made that reference to Stafford, I wasn't actually dealing with the facts of Stafford are influencing me to make this ruling. I was actually reading a quote from an entirely other case that's cited in Stafford just for the legal proposition. So, but thank you.
Yes, Your Honor.
All right.
And Your Honor, that wouldn't, respectfully, that wouldn't be correct anyway. That would be a confrontation clause violation. what the
Right.
attorney's talking
But
about.
that wasn't what I was using it for anyway. So
It's hearsay.
yeah. Thank you. All right. So what's our next portion of this statement?
The next portion that we have, Your Honor, that the defense wants out is page 140, line 11 through page 143, line 16.
Ms. Hilton,
Yes.
I have 89, page 89, 3 to 25. Did you guys agree to that?
You said page 89.
Lines 3 to 25.
Yes, and I believe the full redaction that we agreed upon last time, I have it correct. It's page 88, line 23 through page 92, line 20.
So y'all agree that that's out?
Yes.
All right.
Yes.
There's a small portion that we can play, which was page 91, lines 20 through 21,
91.
line 20 and 21.
Just a footnote from my part here. before Judge Glanville was yeeted, he allowed in worse hearsay than Judge Whittaker just denied. This will be interesting going forward, because if she has a few more of these rulings, then I'm not sure, but she might go back to Judge Glanville's previous rulings regarding Woody's testimony, because how she ruled is so completely different from Judge Glanville. So this will be really, really interesting going forward. I'm so glad I'm here and can stream this.
Everybody good with that?
I don't know, I mean, in reality, I don't know how. Yeah, I'm fine.
Logistically, they're going to
Yeah.
do that? Well, they can figure that out. All right, so then we're looking next at what line, I'm sorry, page 140, line 11 through, did you say 143, line 16? Or did I get that
Page
wrong?
140, line 11 through page 143, line 16, yes.
And I'm sorry to keep doing this, but just so I'm certain, the other three before 140.
Thank you. That's a word. Diametrically
112,
opposed.
24 to 114, 25, we agree on that?
Page 112, line 21 through page 114, line 25?
Yes,
Yes,
okay.
And y'all agree on that being out?
out, yes,
Okay.
Your Honor. And then we also agree upon page 122, line 20 through page 124, line 10. Being,
22, 20. Okay, I'm in concurrence. And then 129, I have 129.20 to 130.20 approximately.
I have 129, line 18 through 131, line 25.
Is out by agreement?
Out.
Okay.
131 line 25?
Yes, sir.
Okay, great, all right. On the same page.
All right, so now I'll read 140, 11 through 143, 16.
Skipping
Give a bit
ahead.
of brief context.
All right.
So after the January 10th murder of Donovan Thomas, there were a number of retaliatory shootings.
Right.
One of those retaliatory shootings was on February 19, 2015, in which Mr. Copeland
Alleged.
is coming out of his home with his daughter and his child's mother. At that time, some members of the opposition gang drive by his house, shoot at him. He shoots back at them, and he's able to find safety.
Mhm.
He goes to the police that evening, and when he goes to the police, they ask him for the gun that he uses. Initially in February, he tells them he'll get the gun. He'll give them the gun. He'll give them the gun. Of course, he never turns in the gun.
Mhm.
Now in June, he is explaining to them why he did not turn in the
Okay.
gun. And so I want to give the court that context before we
Thank
go
you.
into argument.
Okay, and so what's our issue with this portion of the transcript?
Defense counsel, the state believes it should be played. We believe that this is intrinsic to that act from February 19, that it completes that particular story in which this is now the answer as to why that gun was never turned in.
Okay.
And so that's the state's position, that it is, if it does places we don't think it's character, the fact that Shannon Stillwell had this gun. I believe that was the previous argument, that the fact that Shannon is a convicted felon and has a gun is bad character. We don't believe it's bad character, and if it is character, it's incidental character. But this explanation of where the gun is intrinsic to completing the story of what happened on February 19,
All right.
2021.
Couple things. To the extent that the shooting on February 19, 2015, where individuals shot at Kenneth Copeland. The story, the full context, individuals allegedly drive up, shoot at Kenneth Copeland while he's holding his baby, and he's with the mother of his child.
Right.
He shoots back.
Mhm.
He hits people, causes their car to crash. They're charged with this crime. Mr. Copeland's brought into the police station immediately and is questioned about things. He's never charged. Number one, if I concede that the incident itself is relevant to this case, the back and forth, that's fine. I'm willing to do that for the purposes argument. But I don't know what happened to, it's unclear to me what happened to Kenneth Copeland's gun or the gun that Kenneth Copeland fired. That is not relevant. It has no probative value to this case. My client, the fact that he is to be in possession of a gun, he's not charged for that. It's not listed as an overt act. It does place his character at issue. It's very similar to cases that he's charged with in this indictment. I believe he's charged with 2 different counts of possession of firearm by a convicted felon. So the fact that he's charged with that exact same offense that would be implicated here increases the prejudicial value of this information. But in addition to the 401 and 403 issues involved, Your Honor, it's also based on hearsay. He's not claiming to have been there when he's saying Shannon came and got the gun. My understanding of the sequence of events, and I'm not revealing anything my client has told me, I'm just going by what the discovery says. Shannon wasn't present. Mr. Copeland's goes to the police station. He's just been in a shootout. I don't know that he's basing any of this on firsthand knowledge. I think he's just heard this, and it's hearsay at this point. I don't think he's ever saying that I saw Shannon come in and take the gun. That's not the way I understand what he's saying. So I think there's a hearsay issue as well.
I'll hear from the state. So we've got relevance and hearsay
And 403.
and 403.
So for relevance, Sharon, I think it is relevant. Well, let me start with the hearsay first. I don't believe it's hearsay. I believe I'm going back through the transcript that Mr. Copeland explains that when the police came to the house, Mr. Shannon Stillwell was inside of the home, that he left before Mr. Copeland leaves. So I don't think
That's my reading of the transcript too. I mean, whether that's true or not, who knows? But what he seems to be saying is that when the police came by to get the gun, Shannon actually was there. And when Kenneth said, all right, let me go get the gun, by that time, Shannon had actually gone and gotten the gun himself and left the house. And so he was like, I can't get you the gun right now. Give me another day or two. So that's my understanding of it. So that would not be hearsay. So the hearsay ruling, the hearsay objection is overruled.
But how do we know Stillwell was there? That hasn't been shown in evidence. That's only, so far, testimony by Copeland.
How about relevance?
So as far as relevance, Sharon, we believe that the simple fact that he gets the gun from Shannon or Shannon's gun and he has to shoot back at the opposition gang shows one that YSL members, they interchange guns, Your Honor. You're going to see that more evidence is going to come out that we have certain YSL members who may purchase the guns for other YSL members. So this, again, is a part of what the gang does. It's a part of their enterprise and conspiracy. They pass guns around, so we believe that it's relevant for that purpose. And then as it relates to 403, Your Honor, Mr. Stillwell is charged with 2 murders in this indictment, both murders by handguns. So the fact that it comes in that Mr. Copeland got this gun from Shannon is not going to, the probative value is not substantially outweighed by its prejudicial effect, given that the jury is going to hear, at least on 2 occasions, that Mr. Shannon used a gun, alleged to have used the gun, both in the Donovan Thomas murder as well as the Shamel Drinks murder. Additionally, Your Honor, when Mr. Stillwell was apprehended on March 17th of 2022, is the state's allegations that he threw a gun out of the window of a vehicle to dispose of it. So, Your Honor, we don't believe that the probative value is substantially outweighed by prejudicial effect.
If we assume the allegations to be facts, A, we would need a trial, but B, I agree, it wouldn't be prejudicial if we assumed, oh yeah, well, Shannon was in possession of a gun as he rode down the street on January 10th, 2015. But that's not what we do. That's the issue before the jury. So that's exactly what makes this excessively prejudicial, is because that's the issue that they need to determine. And this story, which really adds nothing to the state's case, the idea, it's evidence of passing guns around. I mean, they're going to have direct evidence of Quindarius Zachary saying he's a straw purchaser of guns at Arrowhead Pawn. So they don't need that. And gives it to, and has distributed them to people in this courtroom or in this case. But that's exactly what's so prejudicial about this is they're bringing in propensity evidence that is going to be prejudicial to the issues at hand, which is whether Mr. Stillwell was in possession of a gun and shooting at Donovan Thomas, whether Mr. Stillwell was in possession of a gun and shooting at Shamal Drinks. I submit to you, Your Honor, if Mr. Stillwell was charged with stabbing individuals, this would be less prejudicial.
All right, so
Folks, I'm just going to go back just a few seconds. Look at Mr. Weinstein right now. He's fiddling with his phone. He's actually replying to a question I had at that very moment. I just thought that was very, very cool, but don't tell anybody.
Issues at hand, which is whether Mr. Stillwell was in possession of a gun and shooting at Donovan Thomas, whether Mr. Stillwell was in possession of a gun and shooting at Shamal Drinks. I submit to you, Your Honor, if Mr. Stillwell was charged with stabbing individuals, this would be less prejudicial.
all right, so you're now making a 404B objection also?
Well, it's 404B, but it dovetails into 403 as well. It's just a
Okay, because it really can't be 404B if it's intrinsic. And you just said you agree it's intrinsic.
Well, no, I agree that the shooting itself, the shooting involving Kenneth Copeland, it seems they've argued it's intrinsic, and I don't think that my argument one way or another really makes a difference, but there's a separate incident, which is Shannon's possession of the gun. I don't believe that that's intrinsic.
Okay. All right, thank you. I find this evidence to be relevant and its probativity not substantially outweighed by the danger of unfair prejudice, so I'm going to permit that. What's our next section?
Okay, sadly she permitted that, but they can handle that in cross-examination.
Section I have, defense wanted out is page 188, line 9 through page 189, line 9.
Now, regarding, as I said earlier, Doug did masterful by asking the judge to wait to rule on his mistrial, motion for mistrial. I got a clarification. Doug asked her to defer on his bond motion. It is her choice to wait to rule on the mistrial. Maybe because she has difficulty ruling on it. Because Mr. Weinstein's motion for mistrial is that good. It's that good. And yes, Casper goes, what they are talking about is just gossip, because the only thing they have to back it up with is Mr. Copeland's testimony. That's all they have. We are almost up to completely live.
This discussion.
Oh.
So, Your Honor, this discussion, the context discussion is committee crimes. And so whatever he says, he does. And the context, in bigger, larger context of this, is whatever Jeffrey says, Shannon does. That is a broad character statement in a court. Whatever crimes Jeffrey says Shannon commits. That's a broad character statement that would violate 404B, bad character evidence, and 403, Your Honor, as well. But then, they get into how much Shannon's getting paid, and it's saying nothing. Well, guess who told me? Guess who told me that it's getting paid nothing? Dee. So.
Well, no, then Kenneth Copeland says no.
Oh, I'm sorry. You're right. And then they just talk about how
How Kenneth Copeland can't flex because he doesn't get all this stuff.
Right, and how Shannon's broke is.
Yeah.
So I just don't see the relevance of this. I think it invites, it's speaking in very broad terms, and it's just broad and character evidence about Mr. Still.
Your Honor, so it looks like Shannon told Copeland, and so it'll be a party opponent statement, because he says,
Shannon told Copeland he doesn't get paid.
correct, for the stuff, but what, more importantly, not even to get paid or not getting paid, but that Shannon does anything Thug tells him to do.
No, the Shannon told me that is about Shannon not getting paid.
No, yes, Your Honor, let me be clear. Shannon tells Copeland that he doesn't get paid.
Right.
Yes.
Okay.
We're focused on the other portion
Yeah.
of what he says in here, which is he
But-
does everything that Shannon tells him to do.
That
Um,
Thug tells him to do.
that Thug tells him to do. We have charged Mr. Williams with a leadership charge, which is count 56 of the indictments. And so we believe that that is relevant as it relates to Mr. Williams being the leader of the gang, and now a co-conspirator, member of the gang, is now telling law enforcement this other co-conspirator, this other member of the gang does everything the leader tells him to do. So we believe that that portion is relevant. What is surprising to Kenneth Copeland is that he doesn't get paid to do it, that he does it for whatever reason that he does it. And so we believe that that entire section is relevant for, one, to show evidence of the leadership count, Your Honor, and that Mr. Stillwell has conversations with Mr. Copeland about his role in the gang and why he's in the gang.
I'm sorry, I'm not tracking, and I think I might be missing. Where are we getting that Shannon is the source of this?
Because if you watch the video, and maybe this is one of the ones where you might have to watch the video, he kind of whispers to him, and on page 189, detective says, he said Shannon. Shannon's telling him, but you have to see the video to see it in context, so we can play that portion.
Yeah, but again, that part was about the getting paid.
Yes.
And so what Mr. Shart is asking is, where's your information that Shannon is the source of Mr. Copeland's knowledge that Shannon does whatever Thug tells him?
So Shannon, so a few things. Mr. Copeland, Mr. Stillwell, and Mr. Garlington have all very close relationships.
Mhm.
They have known each other.
Yeah, that's established in the evidence.
Establishing evidence. And so we believe that is his personal observation of what he notices
Mhm.
between the interactions of Mr. Stillwell and Mr. Williams.
All right.
So that's what we believe that's his source of knowledge. That's his lay opinion about what he's observing.
Anything else, Mr. Shart, on this?
No.
All right. I am going to permit this over the 401 and 403 objections. And I don't believe, I mean, it's not improper character evidence. It's Mr. Copeland's firsthand knowledge, and it may be damaging to your client, but sometimes the state's evidence is damaging to the defense. All right, what's our next one?
I don't see this as evidence. It's gossip.
The next one that we had that the defense wanted out was page 202, line 14 through line 20.
And we are in agreement, Ms. Hilton, 197, 14, 199, 4.
Yes.
Did I get it correct? For your notes, the exact lines?
Page 197, line 14 through page 199, line 4. And that will be redacted, Your Honor.
You said 202, 5 to 19?
14 through 20.
Okay, let me ask a question that is entirely irrelevant to what we're doing right now, except for the fact that we're all sitting in this courtroom. How's the temperature for everybody? It seems a little hot for me.
I was gonna say the opposite, seems a little.
Dang. All right, well,
I agree with Ms. Hull.
darn it. Okay, I'm just gonna have to get a fan up here.
What's worth is very cold out here.
Ah, well, it's not up here. Okay.
And Your Honor, heat does rise, so it may be hotter up on the bench.
Yeah, okay.
Your Honor, since we have a.
Yeah, we can have a convenience break. Sure, let's break for until 10:30. That's down as far as it'll go. It needs to be adjusted.
Okay, 10-minute break. Just when we were caught up. All right. Let's see. What do I? There is a few things I wanted to. Let's see here. I will have it up in. Let's see here. Dun, dun, dun. Dun, dun, dun. Okay. Let's share this and make it bigger. This is Brian Steele's motion, plea in bar motion to dismiss General Demur, which was what we were talking about on Wednesday. And this is Steele's argument that the indictment is fundamentally flawed because they left out some parts of the indictment, the wording in the indictment. Renewed plea in bar motion to dismiss General Demur. Comes now Jeffrey Williams by and through undersigned counsel and hereby files this renewed plea in bar motion to dismiss General Demur in the above reference case. In support of this renewed plea in bar motion to dismiss General Demur, Mr. Williams shows as follows. 1. Mr. Williams is innocent of all charges in the above reference indictment. 2. On or about November 2nd, 2023, Mr. Williams timely filed a plea in bar motion to dismiss General Demur in the above reference case. 3. On November 27th, recused Judge Glanville entered an order denying this plea in bar motion to dismiss General Demur. Exhibit B. 4. Mr. Williams timely requested a certificate of immediate review concerning the denial of his plea in bar. However, the recused motion was denied. Oh, where's the rest of it? Hold on. There, sorry, sharing this instead. However, the recused just denied same. 5. On November 30th, Mr. Williams filed a notice of appeal to the Honorable Court of Appeals of Georgia. And on January 7th, Mr. Williams timely filed brief of appellant with the Honorable Appellate Court. On January 19th, the Honorable Court of Appeals of Georgia issued an order dismissing Mr. Williams' appeal, finding that it lacked jurisdiction. Mr. Williams files this renewed plea in bar and asks that this Honorable Court rule on same after hearing from the parties. Mr. Williams relies upon his brief of appellate written from this Honorable Court of Appeals of Georgia, now memorialized as Exhibit C. Wherefore, Mr. Williams respectfully requests this Honorable Court to hold a hearing on this renewed plea in bar motion to dismiss General Demur, and at the conclusion of the same, ask this Honorable Court to grant the above requested relief. So respectfully submitted. And here is the answer, which is a denial. State of Georgia, v. Jeffrey Williams. Order denying defendant Williams' renewed plea in bar motion to dismiss General Demur. Upon consideration of Williams' submission, his oral argument in support, and the applicable law, this court concludes that it is bound by the controlling authority of Tate v. Jesurum v. State, Georgia Appeals from 2023, which controls on this issue adversely to defendant. Defendant's renewed plea in bar motion to dismiss is therefore denied. So that's, not much to do about that, sadly. But it was a good attempt. It was a good attempt. And this is the thing. Hold on. This is the reference in that 2023 case. In Die, the charging instrument, like the accusation against Tate Jerusalem, alleged the defendant, quote-unquote, unlawfully possessed cocaine, and we held that, quote-unquote, unlawfully encompassed both intent and knowledge. That is the thing in Mr. Steele's motion, his argument. Those wordings, intent and knowledge, wasn't in that language. But apparently, unlawfully, which is in the indictment, encompasses both intent and knowledge, according to both Dye and then reassured in this 2023 case. So that is that. So correct ruling, but I do wish that Whittaker would have approved of the certificate, which is more or less, we want to appeal this during trial, and she didn't do that. Louis Thomas asks, is Georgia's RICO law constitutional? It has been upheld in Georgia Supreme Court, but it has never been challenged on a federal level. So, according to Georgia Supreme Court, it is constitutional. We don't know how the United States Supreme Court would handle it. That is the best answer I can give you. Heather Moshe says, knowing people is not proof you tell them to commit crimes. Exactly. Exactly. Let's see here if we can get some other information out. Oh, really? From Joseph says on Twitter, while the young Thug trial is ongoing downstairs, he is upstairs where Fulton Chief Judge Euro Glanville is having his first in-court appearance since being removed from the young Thug case. He is handling the death penalty case against the spa shooter, Robert Aaron Long. Long is already serving 4 consecutive life sentences for the Cherokee County charges, but Fulton County DS office is seeking the DP for his Fulton charges. Long shot and killed 8 people at 3 Metro Atlanta spas on March 16th, 2021. Judge Glanville gets right to it and asks attorneys what they have to address today. No mention of the YSL trial, but I am quite certain that the defense attorneys on a daily basis will ask this court, has there been any ex parte hearing meetings? Which they should, since we now know that Judge Glanville likes to hide things. Let's see, what else do we have here? Let's go check Thugger Daily, what he is doing. Well, this we already know. She is excluding, some evidence. And he says, if she applies the same argument, logic, and ruling to Woody's statements regarding the Nuck murder, the state's case will be severely weakened. I agree. Be on the lookout for a ruling once they get to that portion of the interviews. Yeah, they are still on the bus thingy now, aren't they? So they haven't really gotten to the ending of Donovan Thomas. That's interesting. Let's see what else he has. Okay. Yeah, this we heard Bruce Harvey renews his motion for mistrial, which got denied. Other than that, oh yeah, order denying defendants Williams' petition for certificate of immediate review. Denied. That is that. Oops. And yeah, this we all... Oh, Yeah, here is this is a good one. This is Mr. Steele's suggestion for the jury instruction that we handled earlier. Motion for jury instruction. Mr. Jeffrey Williams, buying through undersigned counsel, and hereby files this motion for jury instruction in the above reference case. In support of this motion, Mr. Williams shows as follows. Mr. Williams is innocent of all charges in the above referenced indictment. 2. In light of the recusal of Judge Glanville, Mr. Williams respectfully requests this honorable court provide the following instruction upon the return of the juror to court for trial. Ladies and gentlemen, Judge Gerald Glanville is no longer the judge presiding over this case for which you have been selected and sworn to try. Judge Glanville was removed as the presiding judge in this case. You are not to concern yourself with this change. In this trial, none of the decisions of the court and nothing that any judge says is evidence. The decisions and remarks of a judge do not mean that the judge favors or leans to one side or another in this case. You are to disregard any comments made by Judge Glanville that were disparaging of the defense lawyers in this case. To maintain the integrity of the jury system, I remind you that you must decide this case based only on the evidence admitted during the trial and the law I will explain to you. Yeah. Now, we heard in the beginning of this stream, this part, well, that part, the first part, that was never going to be, she would never say that. She would never say that. But there is enough in the jury instruction that she ultimately, well, is considering. There's enough there for the jury to put one and one together. Hopefully, having them not knowing why he was relieved or yeeted, that kind of makes it sound worse. Because then your imagination starts running wild. So that might actually be a good thing that she refuses to specify why Judge Glanville is gone. So that will be interesting. Court is still not back. Court is still not back. You want to check in on Cat, not Williams? I want to.
But that doesn't mean that they can't hear it, and the judge at the bench looking out that way.
Look,
she's got to see the
Cat
doors
got
moving and all
super
the
chat.
commotion.
Hint,
And
hint.
it can be distracting. And they might be able to hear it. It might distract the people in the courtroom, even if I'm not hearing it here through the law and crime stream. I've watched other live court trials where you can hear the door slamming, and it's just like you can understand why a judge gets frustrated by it. But yeah, it's interesting that she's going in and out. Thank you so much again for the 5.
I'm just going
Aaliyah, so good to see you. I always appreciate seeing you. Thank you so much for the super sticker. Garrett is busy assigning weekend homework. It's Friday. Well, that's why I think it's interesting that the table behind her, the guys that usually sit there, it's usually 2 guys, but I think sometimes it's been 3 people, but usually just the 2 guys. They're not there today, which is interesting. So maybe the cart usually sits back with them off screen. I don't know. And then Garrett for the 2, sorry, I did that one. And then Dream is a new member. Thanks so much for becoming a member. You now have Mario Kart emojis, which is different than the shopping cart emoji we've been highlighting today. So make sure you use your member emojis. Race in the chat. And then Albert Edens for the 10. Thank you so much. I see Steele cross-examine Copeland and slipping in the judge being removed in one of his questions to Copeland. Guys, it's going to be a fun day. I know I said I don't really watch the testimony days because I usually go in someone else's chat for that. I love evidentiary hearings. I love motions. I love the documents. But I typically watch actual trial testimony with somebody else. I do think I might do the streams when and if Kenneth Copeland gets back on the stand for this exact reason. I want to see how they maneuver, how the defense attorneys maneuver and extract these things that they might not be able to put into jury instructions. And I also want to see, I believe Steele will, I believe there's certain moments where as a criminal defense attorney, we will see somebody make the play call. I might overstep the line and ask a question with verbiage that maybe the judge is going to call me out on. But I'm going to ask it because I know the jury's going to hear it. And I love stuff like that. So I totally think I'm going to stream, if not his whole.
Yeah, I completely agree. Sometimes you ask a question in court just to get the information to the jury, even though you know it is going to be objected to and sustained to.
Trial attorney work. And then Sarah JB93 for the 499 says, has Whitaker ruled on the mistrial motion for Weinstein? Nope, that is still outstanding. And don't forget that he did file, Weinstein did add that supplement all about the June 7th, the new transcript that was disclosed on Tuesday to the defense for the first time. And then no ruling on the mistrial motion. Bruce Harvey did also try to renew his motion orally today, saying like, look, it's just still impossible. So we're coming back, you guys, but there are still outstanding.
All right, and we are back.
All right, so I'll entertain arguments.
I have
Hello, Sylvia.
That is my interest.
If you're amending what you did before, that's fine, but before I have for you, page 202, 14 through 20, but you're saying it's.
I have 2, 5 to 19 in my notes, but either way.
Okay. 2, 2, 5.
They keep going because if she reaches mistrial denied, then she wants to start immediately after, calling the jury saying, we are starting up again, welcome back. So that is why they are doing all this preparation in case she denies the motion for mistrial.
Okay.
It's just a off the cuff, not referring to any specific incident of Kenneth and Shannon getting into arguments and then people coming to shoot at them. And then Kenneth saying Shannon doesn't stand for people shooting at him, is my interpretation. And then where does Shannon keep his guns at? Kenneth Copeland says, shoot on him. And that man got a gun every day. He gonna run though. And we're not talking about a specific incident. We're not talking about an overt act. We're just talking about character. Shannon keeps a gun on him. Get into arguments with people and they shoot at us. Again, not talking about a specific act, just generally, and Shannon ain't going for it when people shoot at us. I mean, all this is just.
All right, so let's
prejudicial and harmful.
kind of take it piece by piece. So there's kind of like the 5 through 13, and then the kind of 14 through 19.
Yes, Your Honor. So first with 5 through 13, Mr. Copeland talks within this interview specifically about another retaliatory shooting that occurred in January of 2015. Again, after Donovan Thomas's murder, there's an incident in which Mr. Copeland, Mr. Garlington, and Mr. Stillwell, I believe they're all in the car together when and they're driving on the highway somewhere near University Avenue and I-75, and the opposition gang shoots at their vehicle. Either before this portion or after, Mr. Copeland tells the detectives that Shannon was upset with him because he didn't want to shoot back at the other car. So I think when you think about that part of the transcript in context with this, what he's saying in lines 5 through 8, but what I'm saying, me and Shannon get in an argument plenty of times because these N-words done came, shot at us, or did something. And what I believe you hear him say, I never did shoot back at him. And so he's talking about that particular
And
incident.
Shannon didn't like that. Yeah, I saw that in other interviews. Okay. And
so we believe that that's relevant, that furthers what he just said earlier.
Where's the evidence of them actually being in the car together while being shot at? Where's the evidence of that? Mr. Copeland? His word? I don't believe it.
In this interview about Shannon not liking the fact that he was not retaliating back against the individuals shooting at them. Now, when you go down to 14 through 19, Your Honor, we do not believe that this is bad character, incidental character, Your Honor. We have a case that I would like to cite for the court, which is Lyons v. State, 309, Georgia, 15, which is a 2020 case, Your Honor. And this case specifically talks about the defendant in this case thought that the trial court abuses discretion in admitting a photograph showing the defendant in possession of a gun because it improperly placed his character in issue and was highly prejudicial. And the Supreme Court disagreed, and I'll just go to what they cited.
309 Georgia.
15.
This has been up before, this specific case. I remember it. The difference is that I believe that photo was dated. They have the metadata with it. The prosecution has, I believe the photo isn't even from Stillwell's own Instagram or something. It's from somewhere else. So it's undated, unverified. There's no way to know if it has been tampered with or not.
Yeah, I mean, is it basically just for the proposition that owning guns and having guns isn't character evidence?
Correct, Your Honor. And what we've also, and it won't, owning or frequently carrying a pistol does not impute to him generally bad character, Your Honor. And so the fact that his friend knows that he keeps the gun on him would be relevant, especially in this overall conspiracy and gang indictment that we have before the court trial.
Anything else, Mr. Sharp?
I'm trying to look at Lyons real quick because I have a suspicion.
Yeah.
Lyons a convicted felon?
Your Honor, I don't know if Lyons was a convicted felon, and I have not found a case in which the court distinguishes if an individual is a convicted felon, that imputes more bad character than not. And I don't know if that's
It's your case you presented, and you claim you don't know if the guy in the Supreme Court decision was a convicted felon or not. Because if that person wasn't a convicted felon, and hence then it wasn't a character evidence, but Mr. Stillwell is a convicted felon, and that would make it more prejudicial than probative because they can't show that that gun in itself has been involved in a crime. Yeah, unless he is a convicted felon, then he has a constitutional right to carry everywhere he goes. So if that Supreme Court decision is about a not convicted felon, then these cases are not similar. Hi, MG Law.
Argument that
I'm
Mr.
sending
Sharp is about to
MG Law a
present to the
link.
court.
Did you hear that?
Well,
Go check your Twitter.
So I'm reading Lyons very quickly, but it seems that in Lyons, there was an argument that the gun in the picture could have been the weapon used in the crime. I mean, that's not what we're dealing with here.
Okay, but is it standing for the, well, whether it stands for it or not, there is a general proposition in the law in Georgia that owning and frequently carrying guns isn't bad character evidence.
Unless you're a convicted felon.
Do you have evidence? I mean, not evidence, you have case law on that?
I don't, but
Maybe let's put that issue on pause then, and y'all do some research and get back to me on it, because that is maybe potentially a different issue than just in general. So we'll have y'all take a look into that.
But I'll also point out in Lyons, Your Honor, it says the photograph was relevant to show that Lyons at some point possessed the type of gun used in the crimes at issue. The probative value of this evidence was not substantially outweighed by its prejudice. So we don't have the same probative value here either.
All right, well, how about we come back to the 14 through 19 portion?
If this had been Judge Glanville, he would already have ruled. This is a good punting forward. Not Judge Glanville punting everything forward. This is a good punting forward, because this shows that this judge, I need more before I rule on this. More actual evidence, more good case law.
Of this page with the gun.
And I never argued about the first part, 5 to 13. I don't believe I did.
Go ahead.
But it's, again, we've got an intrinsic act of them being shot at that's come out in trial. Mr. Copeland and Mr. Stillwell being shot at.
Right.
I don't know why. I don't understand the relevance other than propensity to show that Mr. Stillwell's a quote unquote hothead. I don't know what the relevance of him being upset that we didn't fire back or retaliate or do something. I don't understand. I'm not following how that's relevant.
Okay.
Your Honor, it's not relevant to show he's a hothead. It's irrelevant to show that he wants to retaliate against the opposing gang in the middle of a gang war between these two rival gangs. And so that evidence that while one YSL member didn't want to retaliate, this one wanted to retaliate in this ongoing war between YSL and YFN. And he's also charged in another retaliatory shooting later on in 2022 as still part of this ongoing war between these two rival gangs. So from 2015 to 2022, this war is going on, and Shannon is one of the members who wants to retaliate. And I think that this is evidence of that.
All right. Well, I mean, it also shows the relationship between the two of them, which I would think is relevant to sorting out his basis for. Okay. I am going to permit the 5 through 13 portion in over the objections and don't find it substantially more prejudicial than probative under 403. And y'all can get back to me with any law you can find on 14 through 19. So we'll remember to revisit that.
You want a case, Your Honor?
Yeah, if you've got one now, that'd be great.
So Hall, Hall versus State. It's old. It's 180 Georgia Appeal 210.
I'm sorry, say the first three, 280?
No.
What did you say?
180.
180, an oldie.
We're going back.
180 Georgia.
Appeal
Oh, app. Okay.
210.
Okay.
And it's 348 Southeast 2D 736. It's 1986.
Okay.
And, Your Honor, what it says is the defendant stated on direct that he knew what was in the bag. At worst, he admitted only one of the elements of the crime of possession of a firearm by a convicted felon. The simple rule announced by the Phillips court clearly states that character is not an issue until a defendant admits any prior criminal conduct. However, no criminal conduct could be shown until after is italicized, the prior conviction was admitted into evidence over the objection of defense counsel, because possession of a gun is presumptively lawful. Allowing the prior conviction into evidence in order to place the defendant's character in issue demands circular logic and defies even the broader parameters of the simple rule in Phillips. Here, I'm telling the court that there's an exhibit, I don't know the number, that Mr. Stillwell is a convicted felon.
And additionally, he's charged with possession of a firearm by a convicted felon several times in this indictment. So that increases the prejudicial value because it goes right to a substantive charge.
And to say that he runs around with, I'm sorry, did I interrupt?
Go ahead.
To say that he runs around, he being Mr. Stillwell, runs around with a gun at all times, his conviction is back. It's in this case. Somebody, please help me, but I'm going to tell you it is before the supposed conspiracy even started. The conviction's back to like 2012, I think, but I'm not sure on that. I don't want to make that representation.
The trial, Judge Glanville allowed the state over my objection to actually admit, I think, 5 prior convictions of Mr. Stillwell to establish he was a convicted felon.
Okay. All right. I'll take a look at it over the lunch break and give the state a chance to come up with their own case law on that.
Yeah, I mean, that goes directly to the case that the state argued. This doesn't make it any, and Judge Glanville in excess allowed the prosecution to bring in Mr. Stillwell's prior convictions in excess, much more than needed. But Glanville was he was invested in getting this trial to a jury and a conviction.
So, I mean, are y'all kind of arguing that this is, and by y'all, I mean the defense, are you arguing, I mean, I know you're arguing, so this makes it really prejudicial because it makes it more, well, I don't know, I don't want to rephrase, but are you saying, well, this evidence makes it more likely that they will find him guilty of possessing a firearm as a convicted felon as charged?
Right, he's charged with, I think, 2 counts. Maybe
Okay.
3. And essentially, Mr. Copeland saying, hey, he always illegally carries a gun as a possession, as a convicted felon. And of course, that is, in our estimation, very prejudicial and shows propensity, which should not be considered by the jury when they consider these specific charges.
So on the propensity issue, though, are you saying this is like 404B evidence?
Well, they haven't given 404B notice.
Right, because all of this is intrinsic. And so I'm thinking if it's going to be out on the basis of its, illegal propensity evidence, it would have to not already be in as intrinsic evidence.
Well, my understanding, and I know Your Honor has a long background in appellate law, so I could be wrong. My understanding is intrinsic evidence we're dealing with specific acts. This isn't dealing with a specific act. This is just a gentleman saying, oh,
this man is known to carry guns.
This man always carries guns. He always has one on him. So, I mean, it would be like if someone's charged with murder and then like someone just says in a tape, oh, well, this guy's everyone knows he's the biggest killer of all time, and it's just like, well, that's a problem in front of the jury.
Well, Okay, so I mean, this is essentially, to my knowledge, by me, I mean, at this point, Copeland saying, hey, as far as I know him, and I know him, he carries a gun on him all of the time, which obviously y'all would not like to come in because it does make it more likely that he had a gun on the instances in which he's charged in the indictment with having a gun. But why does that get excluded? So y'all find some law and then we'll take it up after you've presented whatever you have and after lunch. Because I'm not sure that being able to say, I know, from my own personal knowledge of him, that he typically carries a gun is excludable simply because it makes it more likely that some of the charges against him might be true. That makes it relevant. So I don't know, y'all come up with something, hand it to me later. Let's move on to the next thing. We'll circle back on that one.
The next one.
Yeah, as Sylvia says, this is what Harvey meant by she cannot undo what has been done by our departed judge. She can't undo it, even if the rulings are horrible. She already said she has no intent on going back and change his rulings. So they're stuck with it. Just for notice, I will stream up until the lunch break. And then I will throw you all over to Catnot Williams, because I need to have some sleep and prepare for Friday panel show. And today's Friday panel show starts at 6 p.m. and the guests so far are, let's see so I don't get it wrong, Steady Nash, Infamous Sylvia, Kayla Bumpus, Catnot Williams, and Rachel Kaufman. So it will be a great panel of big knowledge about this case, where we go through and discuss what happened this week in this trial. All right. But another hour, and then I need to prepare for that one. Okay? Okay, breaking it down with the...
Ms. Hilton, are we in agreement on 213.20 to 214.16?
Let me
I'm raising the volume a bit because they are not speaking into their microphones properly.
Yes.
You agree, we're in agreement?
Yes.
That it's out. Okay.
Yes.
All right.
And I just want to confirm, we're in agreement 220, 11 to 21?
I have 2/20/12 through 15.
Well, 11 just says overlapping conversation.
You said to 15?
Yeah, 12 to half of 15, so we'll stop after.
Either?
Yes.
Okay, all right, we're in agreement. And then 222.17 to 223.6, is that what you have as next?
Yes, 222. Yes, 222 last time, 223 last.
All right, let me get to that.
skipping ahead a bit.
I'm just going by,
Here we go.
Your Honor, I'm just going by the transcript I have and the amount of writing I have on it. I don't know if the transcript, this might be one that we need to hear the
Okay.
audio.
Do you want to tell me what your objection is or objections are?
Well, from my notes, I believe that Mr. Copeland is claiming that the game was, something involving the game was shot up,
Mm-hmm.
and that Jeffrey supposedly told Shannon to do it. Now, this doesn't go to admissibility. I don't know of anything involving the game being shot up, first of all. So I think this is just a big lie. But that being said, the game had nothing. I mean, this is not listed as an overt act. The game is a gentleman named, I think his name is Jason Taylor. He is not, to my knowledge, we've heard no evidence that he's affiliated with Lil Wayne or anything else. This is just like a completely separate incident that's uncharged in count 1 and uncharged in any other count as well.
So, Your Honor, as I mentioned earlier, during the period of time when there was the conflict between Mr. Williams and Mr. Dwayne Carter, a number of other artists took sides, and we believe that the game took the side of Mr. Carter. And during that portion of time, we actually have entered into a video in which Shannon Stillwell and Quindarius Zachary are in a video threatening the game.
They were in rap battles.
If he comes here, he gonna have to come see me, and he's threatening him.
All right.
Now, what they're discussing in this portion, my understanding, but we'll play it, is Detective Dennis asks, well, how is the beef with Game and them?
Mm-hmm.
And Kenneth says the Game was fixing to get his ass shot,
shot
up, and Thug would have, if Thug would, and Thug would have and told Shannon to do it. Shannon told me out of
probably
his
says if Thug would have told Shannon to do it, because then it says Thug told him no.
Right, and he says Shannon told me out of his mouth he was up.
Where does it say Shannon told me?
When you hear it, so when you hear where it says indiscernible, so I think the last time we heard this portion, there was a lot of dispute in the courtroom as to what it said. So we need to play it.
All right.
And
I also
believe that's the context that's right.
Okay, but so this is essentially somebody not doing something. Maybe y'all want this in. Well, you wouldn't, but Mr. Williams might.
But
so why is it relevant? Because
it's not. It's gossip.
So it shows that Shannon's ready to do anything on behalf of YSL is why we believe it's relevant.
All right.
And that's exactly why it's problematic.
Okay. It's problematic. Why is it evidentially inadmissible?
Well, because it's showing what type of, I'm not asserting this, but the state's asserting is showing what type of person Shannon is. Not that he did this or did that. It's just, as far as the charged acts, it's just showing, oh, he's a hothead that's ready for action.
Okay. Why is that evidentially inadmissible?
Because it's propensity.
To say this is somebody who stands ready to act.
Well, yes. Well, not only stands ready to act, but wanted to act. On it's just like.
All right.
It's bad character, and it's. He's not charged with these events, and they're just essentially Mr. Copeland saying he's the type of guy that would do these events. And I just don't think that he's the type of guy argument. I think that just gets to bad character. And I think that's the essence of bad character and propensity. I respect it.
Okay, well, maybe you want to come up with some law that shows me that it's inadmissible evidentially, character evidence, to establish in a gang RICO case or something similar that somebody who's essentially charged with doing tasks for the alleged leader is ready to do such
It's
tasks
still just
or
gossip.
anything that the alleged leader says.
And Your Honor, also, I'm going to defer to the tape when we hear it, and I've been notorious for mishearing some things on tapes, but I'm hearing was shot up, and if that's what's being said, I would ask that the state provide us with some reports about something happening to the game at some point.
Your Honor.
Because I don't know anything about that.
John, can I add
Yeah,
flavor when you get a chance?
I'm listening.
Okay, thank you. I also think it's important for the court to be aware that the state did not call Mr. Carter, Mr. Dwayne Carter. He's on their witness list. They said that they were going to call him. They did not call Mr. Brian Williams. He's on their witness list. They stated at one point they were going to call him because we have a short list. And evidence came out that, and I don't know how familiar the court is, but when people are in the entertainment business, they advertise themselves, promote themselves, drum up interest by doing things that are, I'm promoting an event for young children, or come to my concert, I'm going to kill somebody. It floods the internet, and it's a marketing tool.
Mm-hmm.
So you're being told like it's proven. It's not proven that there was this feud and Mr. Stillwell was going to do this. There's zero evidence. I've interviewed these people that the game, it's a band. It's a musical band. Game is GAME. That they were shot at, that they were bothered, that there was any issue. This is all the theory of the state. It's also, their real theory is that there's this gang war. I'm just repeating a term, between a alleged gang of YSL and alleged gang of IF. These other people have nothing to do with that. I heard you ask earlier, so this was involved in the, there's nothing. This is just what we've been dealing with in this case. It's just everything has come in on a state's theory without the evidence backing it up.
Yeah.
And then the gang experts, quote unquote, come in and they say, well, this is what we said and we found out. And I ask, well, who'd you find out from? And they say, I don't know. I don't have a file. I can't give you a report. And that's what we've been dealing with. Ms. Hilton said earlier, oh, and Mr. Winfrey pled guilty to this. That's a subject of emotion that I don't think you touched on yet, but I did an attorney proffer. I sent it to you once you were announced as the Honorable Court taking over. I sent you 8 attachments. And what happened in that is Mr. Winfrey did plead guilty. He was charged in another county, Cobb County, before the Honorable Judge Staley. And he pled guilty. He was charged with a RICO violation, gang act. It was a long indictment. He was indicted alone with the shooting on April 26th of 2015. You've been referred to it today as Lil Wayne bus shooting.
Okay.
What the state did, though, was rather shocking. They had Detective Hearsay on the stand. Over objection, they played a recording from jail of 2 people who are not testifying in the case, saying that when Mr. Winfrey gets out of jail in Cobb County, there's $250,000, $250,000, and a Porsche waiting for him, a Porsche vehicle waiting for him. The state took that with Detective Hearsay, it was under the directive of Ms. Hilton, and said, well, that's his reward for not folding and giving testimony against the gang. And then Ms. Hilton asks, Detective Racy, and within a month, Mr. Winfrey pled guilty. So I asked to approach the bench. There's a case. It's Winfrey versus State in the Georgia Supreme Court. I could get to the site that vacated that guilty plea.
Yeah.
That guilty plea was found to be coerced by the Honorable Judge Staley. And it's
Yeah, that is them referencing a plea deal that was later vacated means that that plea deal never happened. By definition, it cannot be used in this court as evidence because it never happened according to law and statute. It never happened. That plea deal was rejected. They cannot refer to something that legally never happened. And they still did, and the Judge Glanville allowed it.
void and cannot be used. I raised that with Judge Glanville to say, how did that happen just now? Judge Glanville would not let me ask Detective Racy about the fact that Judge Staley coerced the plea. It was not a plea. The state comes back after that conference say, and then within the next year, was there just, for whatever reason, another guilty plea entered by Mr. Winfrey? That wasn't true. It was 5 years later. And Mr. Winfrey entered an Alfred plea, specifically said, I do not admit guilt. This is on the record.
Yeah.
And he had the Honorable Steve Sadow, which is S-A-D-O-W, representing him. And he specifically said, I'm going to trial, except I've been in jail for 5 years and I have a time served set. The point I'm trying to make to you, and thank you for allowing me to speak long time. I didn't expect to go into all this, but it is, you know, you need the lawyers to tell you what went on because you're catching up and accurately. And just to say that this is intrinsic, this is extrinsic evidence. This is not dealing with the gang war. This is dealing with an issue that arguably it's up to the jury. I understand that. Arguably is all advertising or puffing. And to act like this is reality without giving you the other side is just wrong. So that's what I want.
All right, thank you. I understand that a lot of this, portions of this case, the state's theory is, hey, they may be saying this in the context of promoting or of singing even, but they're talking about real life and we can use it as evidence. I know that the defense position is, and I assume you're going to argue to the jury if we get to that, is y'all, this is a music industry kind of, this is how the business works. And that's all it is. And that's not up to me to decide. That's up to the jury to decide whether, you know, which theory they think is the convincing one and whether the state has proven its case beyond a reasonable doubt or not. So I appreciate the background and I understand that. With regard to the guilty plea that at the time, I mean, he did enter a guilty plea.
No.
My understanding is, and
No, he didn't. The Georgia Supreme Court vacated it. It never happened. It never happened. Jesus Christ.
I read what you had filed. I didn't know that there was anything still pending in terms of anything for me to decide because that's already happened in this case. And even if his later plea was an Alford, we all know that an Alford plea is this, I mean, he may not be admitting guilt, but it can be used. He's saying, I'm pleading guilty because I think it's in my best interest. Man, I've already basically done the time. I might as well plead guilty and have this done and in my past, but it still can be used as evidence against him. So,
but that was not the plea deal the state used. They used the plea deal that was vacated. Didn't you listen? Damn it, Judge.
So, you know, I may have, I don't know what I would have done with regard to whether I let you probe that issue or not with this witness. But that already happened. So is there anything still pending that I need to rule on with regard to that?
Yes, and this has happened a lot. So Mr. Winfrey, to my belief, is not going to testify either. He's charged in this case.
Okay.
He's in the Fulton County Jail, as, I'm going to say has counsel, but now I'm not 100% sure. I believe he has counsel, but I'm not sure. But there's a case, so he's not here. We can't cross-examine him. The tendering of an Alfred plea or a guilty plea or a NOLO plea. NOLO plea can't be used. So
Well,
ignore that.
right.
A guilty plea or an Alfred plea. The person, Mr. Williams, has the right, that's a confrontation clause. That's a statement made in court for purpose of prosecution. That triggers a confrontation clause.
Mm-hmm.
And that's under Overstreet, OVERSTREET versus State. It's 312 Georgia, 565. Your Honor, it's in footnote 8, 864 Southeast 2D 14, 2021. And in that footnote, it argued a case called State versus Jefferson, like the third president. And what it says is a co-defendant, co-indictee's guilty plea, when they're not testifying, is a confrontation clause violation to be used against, in this case, Mr. Williams.
All right.
So
Let me ask you something. So what he is indicted for in this case, this
RICO.
right, this, this instant case, that's not what he pled guilty to before Judge Staley and then entered a Galford plea to later, is it?
He did, because it's also an overt act.
All right, he pled guilty to something that's alleged as an overt act as part of RICO.
That's true.
Okay.
He being, I'm not.
He Winfrey.
Yes, that's exactly
Okay.
right. But, when saying, yeah, but he pled guilty and it came in, none of it, in my opinion, this is my argument, should have come in because you need the person, in this case, Mr. Winfrey, so he can be asked, why did you plead guilty? The jurors have no clue. And the state did not put in his guilty plea. So it's all oral over objection. So I want you to understand this. When the state is telling you, and I went backward, I guess, but the man already took responsibility, pled guilty, we proved all that. They really didn't prove it. They got hearsay evidence, which I objected to, and therefore it's an objection. Judge Glanville disagreed, but it shouldn't have come in. Judge Glanville let it in for a statement against a co-conspirator, a statement against his interests. He's not here. That doesn't apply either. That man's not on trial.
Okay, so I'm asking what's pending before me to decide.
What's pending for you is going to repeat. The state constantly is putting on guilty pleas of people who are not here, who are not going to testify, and then they use it as a weapon against Mr. Williams. So that's one thing. And then the second thing that you really, why I stood up, I just want you to understand, it is not like this has been proven. That the game and that they were shot at, it's just their theory. And I understand you're saying, yes, then they have to prove it and it's up to a jury. I agree with that. But I don't want you to just buy into like, oh, this is so important because it's already in evidence and the state needs to,
Okay.
evidence is prejudicial.
All right, thank you.
This is good in another manner because even if she says she will not go back and on Glanville's prior rulings, this goes to the last remaining motion to dismiss with prejudice by Doug Weinstein. That is still up in the air. And the more information she gets about Judge Glanville's misconduct and the prosecution's misconduct, even if she says she will not go back and re-rule, it's still information she might use once she gets to ruling on Doug Weinstein's motion to dismiss. So it's good in another manner than just this evidentiary hearing.
Okay, so I'm not even sure where we were
I
with
think we were
regard
going
to
to
this.
play it
Yes,
We're just,
exactly. Okay.
Your Honor, we're going to start just slightly before at 12:16:45.
Shields
And this
asks,
will probably be somewhere.
Shields asks, so you think they will rule on the last mistrial motion today? No. I think that will be, I hope that motion for mistrial will be the last thing she rules on.
Around page 222, maybe around line 1.
She not taking no shit. She not taking no shit from nobody. Well, this, nobody else care about nobody else. You know what I'm saying? Thug ain't taking shit from nobody.
Well, how did the beef with Game in here?
The game nigga did shut up and do it. We told Shannon to do it. Shannon told me his mother was up there winning.
Just give me the word.
Yep. And Thug told him no. Say something on the GD, I can't, Nipsey, Hearsay, something like that. He ended the beef. You know what I'm saying? He stopped. You know what I mean? I ain't here to play. You know what I mean? I just don't want to go to jail. You know what I mean?
And we're going to stop it at 12:17.
All right, if y'all want me to figure out what got said, then I'm gonna have to have that tape. I'm gonna have to slow it down. I have no idea what he said. I mean, I know a lot of it, but the little part that y'all don't know either, I'd have to listen to it a couple of times. So I don't know.
And that's another difference between Judge Whittaker and Judge Glanville. Judge Glanville took the prosecution's word for it. He admits, what's going on here? But the prosecution told Judge Glanville, this is what was said, and he just went, okay, I'll allow it. Auntie M asked, when is the jury scheduled to return? Either 5th, which is on Tuesday, which I believe is already off the table. Alternatively, August 12th. So those are the dates we are working with. Will they return on day 12? Or on August 12th? I don't know. I have no idea. But regardless, if it's the jury's back or if they keep having these evidentiary hearings, I will be in that courtroom August 14th.
You want to play that?
Yeah. Yeah. Not the whole thing, just that part that is kind of hard to, like line 19, the game fixing to get their ass shot up, as I think. But after that is what the. Before you hit play, is the sound coming out of that little white speaker? Is there any way I could get any kind of a speaker closer to me? I mean, is that where that's coming from?
I can't, Nipsey, Hearsay, something like that. He ended the beef.
It may not move far, in which case.
I think that's about as far.
That's not gonna do much, so just put it back where it was. Thanks, though.
Yeah, she needs to bring it back with good headphones and listen to it properly. And definitely not take the prosecution
slower in evidence
word for it.
review, but I can
Well,
play it
just-
multiple times as evidence reviewer.
Who's trying to do that? Yeah. She not taking no shit. He not taking no shit from nobody. Well, this, nobody else care about nobody else. You know what I'm saying? Thug ain't taking shit from nobody.
Well, how did the beef with gang begin?
The game league is shut up and do what told Shannon do it. Shannon told me somebody use up that win.
What I hear them saying is the gang fixing to get his ass shot up if Thug had told Shannon to do it.
And I think it's the next.
Okay.
If
The most discernible.
if
Just give me the word.
Yep. And do it to him. No, say turn on and do it. The game league is shut up and do what told Shannon do it. Shannon told me somebody use up that win.
Just give me the word.
Yep.
Shannon, nobody's something
The
like
game league is shut up and do what.
if Thug would have told Shannon to do it.
Well, how did the beef with gang begin?
The game league is shut up and do what told Shannon do it. Shannon told me somebody use up that win.
Just give me the word.
Yep.
I hear
A theory?
Shannon told me out of his mouth.
Okay, well, I assume that matters. So,
yeah, and what was wrong the last time when they allowed, who I don't remember, one of the officers where they put in another interview, they let him narrate what was said in the recording. Then they played it, and then he narrated it again, which is completely off the charts. That's not how it's supposed to. You are not allowed to narrate a recording the way Judge Glanville allowed that cop to narrate. And now this is maybe 4 months ago. I don't remember which one it was, but I do remember I was furious at the time.
Doesn't matter.
I will listen to that in my chambers where I can actually hear it a little better. So we'll have to revisit that as well, but go ahead.
I'm not trying to beat a dead horse here. I think that when it comes down to it, my objection is that, first of all, anything involving the gang is not charged, is not in the indictment at all. So it is extrinsic in my estimation. I don't know how this fits into the story or is needed to complete the story. In addition, it is bad character evidence about my client. It's a prior, if it's extrinsic, it's a prior bad act as alleged. And also, I'm not hearing the told me out my own mouth. So there's speculation involved as well, or, I don't know what the source of his knowledge is, but he's not saying that he was with Shannon waiting on the game. So there's that issue as well.
Okay, so with regard to that issue, they probably are not doing police questioning thinking I need to establish exactly who everybody. It may be that through this we don't know, and if it comes in, you may just have to ask and maybe establish, or maybe beforehand, what was the source of your knowledge when we have Mr. Copeland and not the jury, and we can find out, is it total rank hearsay or is it not? I don't know.
As long as we're allowed to do it outside the presence of the jury.
Okay, and then with there being a prior bad act, there is no act here, so it can't be a prior bad act.
Well, the act is
Being willing to do what Thug says.
Mr. Stillwell is, according to Mr. Copeland, is waiting, I don't know where, waiting somewhere to shoot another individual. That's an act.
I'm not sure it's a crime to be willing to do it if you don't do it, unless.
No, I'm saying waiting, not, I heard waiting, like he was in, I don't know, I'm just making this up. I'm speculating, but an alleyway or something. I hear he was waiting.
Okay, I don't think that's what it said, but I'll re-listen to it. Okay, let's move on to the next one.
Yeah, I agree with Angelo. All the state has is assertions of bad character and propensity evidence, no actual evidence. I agree.
Of course, prior ruling, Center Deck, page 231, line 5 through /233, line 22.
I think it should start at 230, line 20.
Sorry.
Yeah, 230, line 24.
Well, 230, line 20 says, this is Mr. Copeland speaking, that car that they're saying shot the tour bus. That seems pretty clear to be hearsay.
That's fine, right? Page 230, line 20.
And where did you say it ended?
To 38, line 20. Really, 239, line 2.
Okay.
All right,
We're in agreement with that.
all right.
Next, I have that we agree upon page 243, line 9, and page 256, line 7.
I have 241, line 3. Before we get there, to 242, line 21.
That would
Linda Bernström says, to even seat a jury and not be done with this stuff. Yeah, I know. And the judge said so herself. Why are we doing this in the middle of the trial? What should have been done before trial? And the answer is because Judge Glanville.
It's talk about one of Pee Wee Longway's people shooting up a club named La Cura, which is on Metropolitan, and Kenneth Copeland was initially blamed for it, but it's just talk about that shooting, and then there's talk about Tick, who's Trontavious Stevens, robbing Bentley, who's known as OG Bentley, who is Kelvin Treadwell. It's just a bunch of, I presume, rumors, because I don't think Mr. Copeland was there, about completely unrelated things that he's heard.
Okay, so 241, line 1 through 242, line 14.
I have 242 line. Yeah, that's fine.
All right, so y'all agree that's out? Yes, no?
Oh,
Okay.
yes, I'm sorry, Your Honor. And then Ms. Hill, the next one I have is 243.
Yes, MD Law. All of this should have been dealt with before trial. That's what motions in lemonade are for.
Line, I'm going to say 1 because I don't have a line. 243 all the way to 248, line 11.
All right, so I'm glad we're doing this. What I want y'all to do is get together beforehand, and everything that is agreed to, y'all agree that it's agreed to, so that we spend the court time talking about the stuff that's not agreed to, okay?
Yes, Your Honor.
And I know y'all are doing the best you can, but try to do better.
Well, the next one that's not agreed to, that I can move on to, that I think is page 321, line 21 through 23.
All right, let me get there.
So,
Okay.
MD Law says he said motion in lemonade on purpose. Sure you did. Sure you did.
So,
personal knowledge.
so here, Your Honor, he's repeating, this is a part of that co-conspirator, this is the night of the shooting.
Mm-hmm.
The murder of Donovan Thomas.
Okay.
And he's repeating what the Mikion told him regarding what happened with the murder. And specifically that line where he says, I guess that's where Thug went.
Mm-hmm.
When you listen to Kenneth Copeland, it's not speculation, because this is what the
This is
Mikion
just
told
the
him.
way he talks.
Because even when you look at line 24, he says, and when Thug was at Bentley spot, which was more of an affirmative, this happened based upon what the Mikion told him. So this is all in relation to what we argued the other day regarding co-conspirator statement.
Where is the state getting that he got this particular information from Mr. Garland?
Because throughout here, he talks about, this is what the Mikion told him when he got into the car with him and explained the murder to him once they got to the car.
More
I thought
gossip.
when they got in the car all day.
More gossip. Listen, Judge, we want this gossip in as... Yeah, Doug Weinstein's that comment in his motion that the prosecution is gossiping like yentas. Yeah, that's all the prosecution is. Gossip.
Had time to say was they shot nut, and then like some other little tiny bit after somebody else got out of the car again.
And then that's when they drove up to Mr.
Sky
Williams'
House or wherever.
And Nari got out the car. And it's our understanding that's when more detail came in. That
Okay, and maybe you're understanding, where is the evidence that all of that got said in the car? You might need some time to come up with that.
I'll look again, but what we do know is that he says in this interview that the Mikion told him everything that happened that night. Now, whether
All right,
that
well,
was in the car or not.
I mean, if you show me the part where he says, D told me, what's his name? What's his little D from Mechanicsville, told me everything that went down that night, then we're in a different situation.
So,
Yeah, what's the evidence to back all of these statements up? There are zero.
All right, so I see if we go up a page on 320, around line 9 through 13, or really 17, 18, that he's at least saying, D told me this is all the people that were involved. and he personally knew it because he was with them.
If we go to page 318, Your Honor.
Okay.
Where's the evidence that actually happened? Except Woody's word for it.
Right.
And he says, this is what little D broke the story down. He said, and then he goes into what Demetrian said, which is all the leaving the Sky House. He said they rode past him, let outside. They went somewhere, changed cars. And that was it.
Mm-hmm.
I dropped Shannon D off at Thug's house, and he continues to elaborate.
Right. So that's all what happened beforehand.
Right.
And I think,
That's why I didn't object, no.
Right.
I'm objecting
So,
to co-conspiracy.
I understand. So I understand. So where's the part where we have any kind of foundation that, and I mean, maybe it's just in context, it's clear he told him the whole thing from start to finish. Maybe, but y'all show me where that is.
There is no.
And I guess Lil D broke the story down, maybe.
So, our understanding from this interview is that the breaking down happened in the car.
What doesn't matter where it happened, as long as it did happen, as long as you have some evidence that shows he told him all of it.
This, yes, from
Okay.
everything he says to, the detective in this interview, everything about that murder that night is what.
This is, okay, this is him saying, here is what he told me. Okay.
Thank you so much, Robert Hall. $50 super chat. Safe travels. Hope you enjoyed the Atlanta. I hope I will too. Unless Fanny Willis sees me and throws me in jail. But if she does, I will have so much content. I would start calling myself Fanny Willis. I will start print the merch on that. Fanny Willis threw me in jail. And all I got was this lousy t-shirt. I mean, I don't want to, because I want to keep traveling across the United States. But if she does, I can see myself selling some mugs. But thank you so much, Robert. That is so nice. That is so. Thank you. Thank you. Thank you. Oh, that was very nice of you.
All right, I'll take a look at it more in context over the lunch break. But that seems to be a pretty good basis for arguing that.
And he says it earlier, so this is the second time he's telling the story. So for the purpose of this interview, Your Honor.
Okay.
He tells the story initially early on in the morning to Detective Gaither, Detective Dennis,
Yep.
and detectives. And then later they bring in Detective Thorpe, who was the homicide, the lead detective on the Thomas case, and he reiterates the story again with a little bit more detail in front of Detective.
Okay.
So he's telling them
All right, and he's already said, I got it all from Lil D. Okay, all right, I mean, I think that is satisfactory, as, yeah, he had a source for this.
The next.
I have 341 to 341, I think 19 to 350, 17.
Is that the whole BB?
Correct.
Yeah, that's not an issue.
Okay.
So that is out by agreement? Okay.
And then 356, 9 to 19 was the same issue, I think.
Yes, I think I have the full redactions, 341 line 19 through 350 line 13.
What about 356?
Yes, 9 through 20.
Yes. And Ms. Hilton, the next one I have is 361, line 1 to 362.10. I don't know if we had agreed to that or not.
I'm trying
What
to
I
get.
have is the final.
Yeah, I've been trying to coax Doug Weinstein in representing me if Fonny Willis throws me in jail. I'm not entirely there yet, but I will keep working on it.
Is that we were going to take out 361, part of line 16, so line 17, where it says Shannon shot up that tour bus.
Say the lines one more time.
Half of line 16 and a portion of line 17, the sentence reads, Shannon shot up that tour bus.
All right, so that's out by agreement. There may be another part we need to take up, right?
Right, well, part of that, Detective Thorpe says, listen, this is 362 lines 7 to 10, which was included in my objection.
I'm sorry.
I guess the state doesn't agree with that. Detective Thorpe,
Oh.
listen, because you said a key piece of stuff we've been asking you. You said without a hesitation, without a doubt, Shannon the one who shot the gun. And then Kenneth says, y'all keep thinking I'm doing stuff. And I'm not 100% certain on the context as I sit here now, but it's right after discussing the Lil Wayne.
Well, what I believe is happening in this portion, Your Honor, if you go back to 361, Kenneth is elaborating that he's not the problem, it's Shannon. And so he goes on and he's saying Shannon is doing everything. Specifically, he says Shannon killed Nut, Shannon shot up that tour bus. Based upon prior ruling, we know that should come out. Then he continues to go on.
That was an absolute horrific ruling again by George Glanville, because there is literally zero evidence Shannon Stillwell was even near the bus. And remember, former ADA Sprinkle recommended the case against Stillwell in the Nut shooting to be dismissed twice because there was zero evidence showing guilt except Woody's testimony.
And he's saying, I ain't retaliate one time, now I'm on 362. And then Detective Thorpe, I guess, is trying to clarify, I said, because you just said a key piece of stuff we've asking you, you said without a hesitation, without a doubt, Shannon the one who shot the gun. Because, and this will be speculation on my part, but I think because he's the investigator of the Donovan Thomas murder, that is what he is focused on. And then Kenneth Coleman doesn't even respond. He just says, y'all keep thinking I'm doing shit. I'm not doing nothing. I'm telling you, I'm fixing to go back to jail. I'm not trying to hurt anybody. So he doesn't even respond to Detective Thorpe.
So maybe we could just take that part out then?
It seems right.
The Detective Thorpe part?
Well, without a hesitation.
Yeah, okay, so why don't we just take out 7 through 11? So 362, 7 through 11. Or 10 or whatever. 10, I guess. Okay.
Yes.
All right, next one that we have dispute about.
The next one we have this.
Yes, because y'all can spend your lunch break talking about the ones you agree on, and then you can come back and put it all on the record. I guess if you don't know, then we have to talk about it now.
Look at 365 lines 6 through 8.
$365.
This is one of my main problems with the RICO charge when they allege a criminal enterprise. It seems like gossip can be accepted as evidence because the claim is, well, we allege it happened and we have a witness, this Woody, who said it happened. So let's leave it to the jury. But if they didn't have the RICO charge, it would never even reach trial because there is simply no evidence. And that is infuriating.
Yes, that's in this. That's in dispute.
Okay, so, Your Honor, on 365, 6 through 8, the context of this is Quindarius Zachary, also known as the other little thief, from Cleveland. He allegedly would buy, he's not a convicted felon, he'd allegedly buy guns. At some point, he bought a gun for Kenneth Copeland. Allegedly, Kenneth Copeland ends up getting arrested. Then he wants to get the gun back, but then wants to get rid of the gun. And it's a gun that's later, my understanding is later, Kenneth is arrested for because he's carrying it to the Dunbar Rec Center and leaves it in the bleachers. Kenneth is saying that Jeffrey told Quindarius to buy the gun back from Kenneth. However, Kenneth was incarcerated throughout that period, my understanding. So I don't believe he's speaking on firsthand knowledge. He's just speculating or passing on hearsay that Jeffrey instructed Quindarius to buy the gun back from Kenneth. I don't believe he has any firsthand knowledge of this.
So I have a different analysis. I believe that they are talking about initially buying the gun from the pawn shop. So if we go, but they're talking about the fact that Quindarius buys the gun, specifically most of the guns from Arrowhead Pawn Shop. And for the reason that Mr. Shard stated, the state believes because he was not a convicted felon, he would purchase a number of the guns on behalf of YSL members. And what the detectives are saying to Copeland is, you told him to buy the gun.
Right.
And he said, no, Thug told him to buy the gun initially. And then later on, there is some conversation about Mr. Copeland was arrested and he was going to try to sell the gun, which when he got out, and that's how he ended up.
Yeah, this looks like the buying it to begin with, not the buying it back afterwards.
Well, either way, Your Honor, I don't see any indication that it's anything but hearsay. And here's the other thing. Quindarius Zachary's apparently going to be called. So Quindarius Zachary would certainly have firsthand knowledge of who told him to buy a gun. And right now we have Kenneth Copeland on an out-of-court statement, possibly speculating or passing on hearsay. And it seems to me that we would have a live person on the stand that could answer that question pretty clearly.
My position is, one, if this statement comes in, it'll be contingent upon us asking some foundational questions on the stand first. And then depending on what his response is, this would probably be a prior inconsistent statement, depending on what his answer is. I don't know what it will be, but we can lay more foundation as to when how did this come about? How does he know Thug told him to buy the gun or not?
All right.
I would just ask that the foundation is laid
Outside the presence of the jury. Yeah, absolutely. Outside jury. I just wrote that down.
Yeah, this is excellent that this will be kept outside of the jury. Remember, Judge Glanville allowed a Daubert hearing of an expert witness in front of the jurors. Because I believe it was former Detective Gaither, the defense didn't get her CV until the morning of her testimony, which should have gotten her excluded as a witness, because way too late. Her CV should have been in the filings before the trial started. They waited to give them her CV until the morning of her testimony. And then they held a Daubert hearing in front of the jury.
Okay, so we'll need some foundational questions.
Yeah. Wait until Nick goes to Walmart and sees the land wills. I will go to Walmart because I need to stack up in the car some stuff that I need with me on the road trip. I mean, I need a cooler, I need water, I need, if there isn't a first aid kit in it. Angela, what? A Daubert hearing in front of the jury? Yes. Yes, they did. In front of the jury. The defense objected furiously, because if you have a Daubert hearing in front of the jury, the defense have to ask specific questions that might, in front of a jury, incriminate their clients, even if they speak in hypotheticals. When they are in front of a jury, that cripples the defense, how they can challenge her credibility as an expert witness. Yeah. And Judge Glanville allowed it.
On that. Assuming you can lay the right foundation that he actually knows it, then he ought to be able to say it. But we don't know that yet. All right. Hang on just a second. Ms. Winfrey.
Oh yeah, Angela. When she started testifying, they started out with her as a fact witness. And after, I do believe, a day and a half of testimony, they told Judge Glanville, now we are switching over to her as an expert witness in the middle of direct examination.
I believe there was a.
Yes, I will get a hat in Houston. I will try to get a meetup with Kurt on civil law so he can get me to a hat shop so I can get a proper cowboy hat that fits my giant head.
Portion of, so page 375, line 17.
Angela, oh, you sweet summer child. Don't you know that in Judge Glanville's court, whatever the prosecution asks for, they get?
Page 376, line 9. The state only had an objection to page 375, line 17 through 19. Defense counsel wanted that line out. That Mr. Coleman says Doug is connected to a lot of people. We wanted that portion in. But that was.
I don't have a problem with that. And then 375.
All right, so hang on. So all of 375, 17 through 376, 9, there's no objection to. Is that right? Is that right?
Yes.
Coming out.
Okay. Wait, coming out or staying in? Y'all seem to be saying.
We're agreeing that it comes out.
Wait, hold on.
It depends on how it suits my head. I have a giant head. I mean, Let me just check here. Let's see here if I get one. Find your hat size. I am 7 7/8 in size. And it's weirdly shapen. So my grandma, rest in peace for a good number of years, my grandma on my father's side, whenever when we were visiting grandma and grandpa, they took us shopping. And her absolutely biggest joy in life was finding hats, try them on, and asking grandpa, does this fit me? And grandpa just looked at her, you're crazy woman. She couldn't fit. She barely, I mean, no, her head was so weird. And that's some character among the family. And yeah, so we will see if they can get me a correct size hat. Gwendolyn says you could wear your helmet. I don't think wearing this while driving through the southern states, that might get me arrested.
375 lines 1 through. You said 1 through 9, Your Honor?
No, I was saying what you said.
Oh, I'm sorry. Yeah, I thought I
You
heard
said 375, line 17 through 376, line 9. Are you agreeing that all of that is in or all of that is out?
I think everything from 375:20 through 370. Everything from 375:20 through 376:9 is out.
Out. Okay.
I agree.
All right. All right. What's next?
I have 378, 1 through 8.
Notice the difference. Last time we heard this in front of Judge Glanville, it was a faster clock. Listen here. They speak in turn, and she makes rulings or deferred forward for more information. Ta-da! And this should all have happened before trial.
You said 378, 1 through 8? Yes, that is.
Agreed. Out.
No, that's in.
Oh, okay. All right. Tell me why that's in. Oh, I see. That's not the detective saying 7 through 14. That's Mr. Copeland.
Yes.
So then, Mr. Sharp, tell me why that's out.
Well, two reasons. First of all, it's speculation about what other people will say. And also it's a comment on individuals' right to remain silent. I mean, they're asking, if we call people in here, who's going to tell, who's going to give it up, and then he just speculates. And I don't think that's relevant. I don't think that's appropriate.
Thank you for listening.
So I don't know why it would be a big.
Mel says they are not going to be ready for the jury by the 5th. No. What they are discussing now is the first interview the state wants to admit. A 9-hour-long video. That's what they are debating. There are 2 more. No. Well, it's a combined total of 13 or 15 hours of police interviews with Woody to go through. And after that, you have the jailhouse calls, which are additional 3 hours to go through. Yeah. And then you have all the witnesses that the prosecution wants to call the coming 2 weeks. Those 2 needs to be handled. So yeah, I do not believe that they will be done by the 5th. So they will probably reschedule jury coming back to the 12th. I'm quite certain of it. Oh, Jesus Christ,
What's your scope say?
Your Honor, so this is a portion, if you look at
we are a few
right
minutes
before,
behind.
on page 377.
Again, I will continue to launch. I will be shipping you over to Cadnot Williams to her stream because I need to prepare for the stream that starts 6 p.m. Eastern Time with the panel, which includes Sadie Nash, Infamous Sylvia, Kayla Bumpus, Cadnot Williams, and Rachel Kaufman, and myself.
The detectives are asking Copeland, specifically talking about the murder, who do you think we can call in? Who will speak to us about the murder? And what Kenneth Copeland's response, beginning on page 378, line 1, put it this way: Thug and them already knew those 4 right there. They're not going to tell. He's talking about Yak, Nard, Shannon, and one other, and Supermama, who's the 4th person. And he said, I don't know about doo-wop, but them niggas not going to tell. That's why they're not saying it. You feel what I'm saying? I understand why everybody doing this stuff, but I at least want to make a way to be like, well, Woody told us. You feel what I'm saying? This is a YSL member who knows the individuals in which he is around. He knows who will come and talk to the police and who will not. And so who will protect the enterprise. And that's what we believe he is telling them, like, these people are not going to talk about our activity. So there's no use in you trying to speak with them because they're just not going to talk. And Thug knows that they're not going to talk as well. As it relates to commenting on pre-arrest silence, Your Honor, I'm looking at an 11th Circuit case, United States v. Reeves, REEVES 742, Fed 3rd 487, which is a 2014 case. And
Sorry, just tell me that whole side again.
Sorry, and if I went too fast, I apologize. United States v. Reeves, 742, Fed 3rd 487.
Okay.
And the key holding that we have is the government may comment, and it's really on a defendant's silence if it occurred before the defendant was in custody and given Miranda warnings. In this case, at this time, none of the defendants were in custody at all. They were still investigating the homicide. At this point, no arrest warrants were even taken out. During this interview in June of 2015, warrants were not taken out until October of 2015 for the murder of Donovan Thomas. So this would not be commenting on any pre-arrest silence, Your Honor.
Okay. So aside from the pre-arrest silence objection, what other objections do you have?
Well, it's speculation, and it's also, I guess, relevance. Like, why is Kenneth Copeland giving why would a jury hear an out-of-court statement by Kenneth Copeland about whether my client will give a statement to the police or not?
All right, so y'all had pointed.
Republic Room gifted with membership. Nice. And it went to KMAT Red Queen. Congratulations. You now have access to my members only stuff. And it's a lot of it. For instance, this Saturday, really early in the morning for you guys, but Cosmic Creation, the trotter I own a 1% stake in, is having a race. So I will be for members only. I will stream that race live tomorrow at 7:15 a.m. Eastern Time. Yeah, so that is one of the member perks. You get to know more about me personally, not just the law stuff, but stuff I do besides streaming. All right. Thank you so much, Republic Room. That is so very nice of you.
As the objectionable portion to 379 lines 1 through 12.
No, 378. I'm sorry.
Okay. That makes a lot more sense. All right, I don't find it to be any kind of a pre-arrest silence kind of potential violation. And this is his opinion as to how strong they're going to be with backing up and keeping silent about what the gang is or is not doing. I think that that's permissible for him to say. I don't think, I mean, it's only speculation to the extent that anybody's opinion about anybody else is speculation, but it's valid to come in. So I'm going to permit that in. What's next?
The next portion that I have as in conflict was page 386, line 20 through page 387, line 12. And
Is that in dispute?
yes, yes, Your Honor.
Okay.
I don't have the dispute quite as broad. I just have the dispute over 387 lines 6 through 13. And it's just simply hearsay.
So, Your Honor, the state would say that this is not hearsay. We're not offering lines, page 387, lines 6 through 12 for the truth of the matter asserted. When you go back to page 386, Mr. Copeland, I think it's around here, he starts explaining he never had an issue with Donovan Thomas, like that they've had conversations with each other. And some of the subject of that conversation was Mr. Copeland's relationship with Mr. Thomas's brother, Kelvin Watts. So when you get to page 387, lines 6 through 12, he's telling them about a conversation that he had with Mr. Thomas prior to his death. Now, whether or not
That cannot be
Mr. Thomas said, I'm
substantiated,
gonna go
and
holler at
nobody
them, or
else
whether or not
has
Mr.
said
Thomas
anything
did go
about
holler at Kelvin, is not what we're offering it for. It's solely being offered for the fact that they engaged in conversation that was amicable prior to his death. And so we're not offering it for the truth of the matter asserted.
If it's not offered for the truth of the matter asserted, then it's not relevant and shouldn't come in.
All right, so it's on 386 where he's talking about actually having the conversation with Mr. Thomas, right?
Yes.
Okay, and that's fine. That's not objectionable to the defense. So the part that they're objecting to is the part where, I guess, who is it that's walking up and saying this? Shannon, right?
No, so when we go to 6 through 8,
Yeah.
he's saying that Shannon was right there in the presence when the conversation was happening.
And it's Shannon who says, if I'm understanding it right, man, what's up with you and Kel, right?
No, it's Donovan Thomas.
Oh,
OBCNB question. If I'm not mistaken, she still has 2 rule on a motion or 2 to mistrial. This can all be for nothing, correct? Yeah, it can. But speculatively, and this is a theory I've heard elsewhere, is the more she hears about the rulings Judge Glanville has made prior, the better the chances are that the mistrial might be granted. So it's 1 or 2 more motions for mistrial that she hasn't ruled on yet. Legendary Racing, thank you so much. Gifted 5 memberships. And it went to Mel, OBCND, Gwenin Garnett, Heather Mosher, and Lady Star. Thank you so much, Legendary Racing. That is so very nice of you. Thank you so much.
he was like.
And he's referring to is Donovan Thomas. So.
And I agree with her.
Okay, all right. Okay, and so you're not offering it for the truth, you're offering it for the fact that Taylor Copeland and Donovan Thomas are cool with each other.
Yes.
All right.
Well, I mean, that only comes out in 386 that they had a conversation. My objection is when Kenneth says what Donovan Thomas said, allegedly said, which is, man, I'm gonna holler at N-word and I'll let you know what's up. Because it's giving the impression that, and it is coming in for the truth of the matter asserted, that Mr. Thomas was playing the role of peacemaker.
All right.
And
So I'm sorry, I don't mean to interrupt, just for purpose of keeping the record clean. So now what we're really talking about is just lines 10 through 12 of 387, right? Okay. So in that, they're saying, hey, man, you got to be offering that for the truth.
I mean, they make their point without, the point that they're claiming to be trying to make is made without that last part.
But I think that gives context when you continue to go further down that page. And when he says, that's what Nut said. And then Kenneth says, yeah, so when me and Kel seen each other, I believe he says, when me and Kel seen each other at the skating ring, Kel was like, well, he wanted to see what Thug got to say. So I called Kel on FaceTime.
Okay.
But give us some more history. In the week leading up to Donovan Thomas's murder, there are a couple of events that
Yeah,
occurred.
I actually am already familiar with the skating rink event.
So it appears that on that Sunday, Kenneth believes, based upon his interactions with Donovan, that him and Kel are cool. And matter of fact, they actually do talk and have a conversation. And then the next day is when Kenneth Copeland gets beat up at the skating rink. So all this is in context of what is happening or developing those days leading up to Donovan Thomas's death. So I think it puts the second part of this page in context.
But the only way it provides context
Is if it's being offered for the truth. Right. I was about to say, so now you're conceding it is being offered for the truth.
Not whether or not he hollered at him, but the fact that they just had this conversation, whether or not, because we don't know if he hollered at him or not. We just know that something may have occurred, then they saw each other the next day. Donovan might not have ever talked to his brother that day before. We don't know. We're not saying he definitely went and spoke to Mr. Kelvin Watts once he left that meeting. We don't know. We're not offering to say he did talk to him. We don't know. What we know is the results, whatever that conversation was, there was an amicable meeting between Kelvin and Mr. Thomas.
Even to the extent of the discussions about his own brother, it was amicable.
Correct, whatever.
Okay. But not for the truth of whether he's actually going to holler at him. Right. All right. Well, that seems like it's then not offered for the truth. So, all right, that can come in.
But then it's not relevant.
Let's take a lunch break. I know the lunch is here for the defense.
Oh, and MG Law, 5 membership. Thank you. Gifted to Patty B, Paradox True, Paula Carpenter, Patty G, and Larissa Flanagan. Now you also have access to all my members only content. And regarding Cosmic Creation, that start is scheduled for 1:22 p.m. my time, which is 7:22 a.m. Eastern time, Saturday morning, and I will live stream it. Republic Room asks, is there anything that's solid evidence? No. Everything is garbage, rumors, gossip, and geez, now you're getting into it. Iron Rabbit gifted 5 memberships. Thank you. To Fat Grandma, Shafos, Dweez, it's Rebecca Starr, and Mads were gifted memberships. Thank you so much, Iron Rabbit. Thank you. Thank you, thank you, thank you. Wow. This stream has been on fire. I need to stream more. I will stream Monday, Tuesday, and Wednesday is my travel day, so I can't. Thursday, I don't know. I will be visiting the convention in Houston, the Matsuri convention, but I will post on my travel channel. I will post stuff, videos, shorts, and stuff. I will always listen in on the trial. I will make videos and stuff like that. I don't know how much I can live stream. It depends on my access of free Wi-Fi. But I will try to stream as much as humanly possible. It might be that when I get home, not get home, when I get into the hotel room or wherever I'm staying, that I will do a 1 to 2 hour stream regarding what happened in court that day. I should stream while I travel. That would be eating up my... I will be traveling with one of these AT&T's 30-day tourist thingy, but I think I only have 50 gig on it, and streaming live will take a lot. But yeah, I will do it as much as I can. As much as I can.
So let's be back. Will it be enough time, you think, to get everybody fed to come back at 12:20? Not 12:20. No, that will not be enough time. 1:20. 1:20. Will that be enough time? I'm asking the deputies. Yep. 1:20.
All right. Then they are out on lunch. And as I said a couple of times, I will stream until lunch. I will send you over to Catnot Williams because I need to prepare for the panel show that starts at 6 p.m. So I need a bit of sleep, and I will have a bit to eat. So I will be prepared for tonight's panel show with me, Sadie Nash, Infamous Sylvia, Kayla Bumpers, Catnot Williams, and Rachel Kaufman. So now I will send an invitation to Doug. I will not expect him to join because he will have a lot to do over the weekend. Okay. Everybody, thank you so much for allowing me to do this. Thank you so much for your generosity, for the subscriptions, the thumbs up, the occasional super chat and memberships. Thank you so much. And folks, hug your family. Unless your family is crap, then screw them and give your love to the people who deserve it. Okay? I will see you later today. And everybody say hi to Kat for me. Okay? Bye-bye.